Adjournment request, if any, from item number 1 to 7.
May please log. In item number 1, we have filed an affidavit in reply yesterday, my lord. Can you be called for me?
Have you supplied the copy to the other side?
Yes.
Item number 8 to 14.
Regarding item number 5, service is not completed.
Delay condemnation, no office, no transport, no neither AD card received. Respondent number 6 is still unserved.
Yes, Your Lordship.
Let the number comes, we'll pass it out.
May I please, Lordship, with the concern of others, I beg to mention item number 14, Lordship. Yesterday, we have circulated the adjournment slip, Lordship. In this case, in response to our RTA reply, RTA queries, Lordship, certain replies we have received, Lordship. Lordship, we need some time.
Adjourn.
4 weeks, Lordship.
4 weeks.
From item number 15 to 26.
My lord, in 26, my lord, we have prayed for a joint adjournment, joint payment adjournment. My lord, let the matter come up next week on a hearing day, Thursday probably. And it's, my lord,
Item 40 is.
40 is also connected, my lord. Supplementary list.
Item
40 of supplementary list.
supplemental list. Okay, both adjourn.
All right.
From item number 27 to 37.
Hey, please, Lordship, I beg to mention item number 27, Lordship. Some instructions are required, Lordship, after 2 weeks.
Adjourn.
Oblige, your Lordship.
With the concern of others, I beg to mention item 37, Lordship. Yesterday, we have circulated, I think.
30.
Adjourn.
May it please, your Lordship. Lordship, in item number 34, I have filed a additional affidavit that may be kindly confirmed.
Call for that. May I, my lord? With the concern of the other side, my lord, I beg to mention item 35. I have circulated the slip, my lord. Adjourn. Much eligible.
May it please your lordship. With due concern, I beg to mention item number 32. Lordship, let it be listed after 2 weeks.
Adjourn.
Obliged.
May I please, Your Lordship? I'd like to mention item number 17, Lordship. Kindly matter may be adjourned for the day, Lordship.
Number?
You are for?
I'm for the petitioner, Lordship.
17.
17.
Adjourn.
Oblige.
Any other request?
May I please, your Lordship? Lordship, I beg to mention for listing of 2 writ appeals and 1 writ petition, my lord. And it'll be on Friday, my lord.
Red petition before the division bench.
My lord, challenging a rule, my lord.
Next,
Fine.
my lord.
Obliged. May I please, your Lordship, I beg to mention item number 38, Lordship. Yesterday, I have circulated the adjournment request also, Lordship. So I am
Adjourn.
paying for 1 week, Lordship.
Adjourn, adjourn.
38. 38. Deeply obliged.
Daily list for orders item 1.
Before I go to that affidavit, my lord, let me explain your lordship's query regarding paragraph 5 of the impugn order. Perhaps your lordship has his copies.
Paragraph 5.
Lord, to be very frank, it was my inability to explain. The brief was so big, but I escaped this. Let me read it, madam. Order in the file number 642 NS1 maintained by the BSNL authority, it has been clearly mentioned therein that 54 casual employees who have completed 240 days of work in each year for 33 years as on 31/3/2004 are entitled to productivity lien PLI. And accordingly, all the applicants was paid PLI for the 2004 and 2005, Annexure 1 to rejoinder filed by the applicant against the additional written statement filed by the respondent. Most important, this part, subsequently, when the matter was pending before the higher authority, the authorities had withdrawn 52 numbers of casual employees to applicants and to other casual employees from their work on 2007 to 27. And from the same date, they were placed under the contractor to the same work, which they were doing all along and retain 74 employees from the list of 228 numbers of casual employees under the BSNL. Out of 174 casual employees, 150 numbers of the employees are much junior to the applicant. However, those 174 employees are being paid daily wages rupees 234, wherein the applicants are being paid only wages 80 only. Thereafter, the applicants have filed various representations to the authorities on so and so, and since no response was received from the authorities being received with applicants that filed the in my respectful submission, I don't call it a finding, but even if it your lordship, because your lordship had drawn my attention to this while I was reading our it was a wrong finding. Namely, my lord, that if we have withdrawn it really and then placed it before on the contractor, we can't escape. That aspect has to be resolved. And if your lordship kindly sees other judgments and findings by the tribunal, nobody resolves this. Nobody resolves this issue. Namely, we have never withdrawn any employees or placed under the contract.
Under the contractor.
Contractor. They have left on their own. Thereafter, where they have gone, we do not know. Then, my lord, this is a matter.
Sir, what you are saying that you have not placed any of the employee out of this 174 casual employees or whatever the number may be under the contractor and they left on their own. Where is your government?
Yes, I am coming to that.
Yes.
Your lordship will say first thing, if I show from this paragraph 5, what is the evidence in it?
So evidence, you just show us that you have stated before the tribunal that they left there on their own, you have not withdrawn them or not placed under the
Millard.
contractor. Where is your government?
No, my lord, let me point out something. Our rejoinder in the reply is not very happily drafted. By implication, this is there. No, I will point out, my lord.
We have to go by the pleadings. only,
Yes,
sir.
sure, no doubt about it. My lord, I will agree. I'm not going to say by who got proved, I have to say. Now, this withdrawal, let me show their defect. This withdrawal, they say, in the affidavit, matter of records. And the learned tribunal has only quoted their averment. No record. Your lordship would kindly see, there is no record at all. If your lordship kindly comes to their affidavit. Miller, the crux of the problem, according to me, if I understood correctly, this is the crux. If we have placed it under the contractor, then we can't escape the liability. And they have to show that we have withdrawn it. Let me show from here itself, 2004 and 2005. Thereafter, where did they work? 2005, 6, 2006, 7. They filed the case in 2009. What they were doing so long? Not even a single document. That before that they were working with us and we have withdrawn. Some document will be there. At best, my lord, if we have placed them under the contractor, when? Because the concept of putting it in the contractor, it
On-
came only
On
2007.
on 20th of July 2007. You place them under the contractor on 20th
no.
of July 2007.
No. We engage contractor, we have given Miller that new affidavit. If your lordship wants to see that. And this file Miller mentioned here, 642, that we have brought on record. Let that come, Miller. Your lordship has to see this file.
Mr. Bhattacharya. Mr. Bhattacharya, no, Mr. Mr. Nath, with your OA,
My lord, in yesterday they filed an affidavit. In that affidavit, they only annexed that way.
that affidavit,
Yes, that
No,
way has been annexed in
just-
that affidavit. Yes,
First-
not in the writ petition.
you pointed out your,
Yes,
where
yes.
is that OA?
Way. That,
Where is your OA?
that they have annexed
Miller, they
in the last affidavit yesterday, not
have
before.
annexed it.
Okay, give us.
My copy, lordship.
Where is this averment in relation to para number 5 in the OA? Which para you have?
Para, my lord, that paragraph
4.4.
5.4, paragraph number
5.4.
5.4, yes, 5.4. Kindly read, my lord.
No, this is on 4.
The entire para, lordship will read kindly.
I don't know what it is.
What is the, where is the reply filed on behalf of?
My lord, page number 203.
203.
Yes. Para 12.
Yes. Yes,
That's my affidavit. I've annexed that WS.
this is the counter affidavit.
Yes. In respect of OA, there's the counter affidavit they have filed.
That.
It starts, my lord,
Yes,
page
yes.
number 195, it starts. Clear copy of OA, my lord. This is without annexures.
This is your way.
This is the way, minor is marked on, this is the unmarked on, my lord. This is without annexures. এবার একটু দেখে গেছি।
0.8 of the woman. You are selecting. Buddha will do.
Yes. Yes.
Your lordship would kindly see page 4.A of the OA.
OA.
Yes. Page 229. Four point A.
Yes.
Second paragraph.
In a 42,
Decline. Second paragraph.
second paragraph.
Yes.
May I read it, madam? Surprising while your applicants along with other casual employees as mentioned above have been anxiously waiting for regulation of their services. This is in connection with regulation. The respondent authorities have withdrawn the above mentioned 54 casual employees, including your applicants, from their work and placed them under contractors as contractual workers with effect from 27/77. However, the remaining 24 casual employees for Arunachal Pradesh, some of whom are much junior to your applicants, have been retained by the respondent authorities as casual employees directly under them without disturbing their position. Even one of the 154 casual employees where names have been sent to the higher authorities for regularization have been treated as contractual workers. Although the BSNL employee union register to which your applicants are members have written to the respondent authorities to several occasions for withdrawal of 54 casual employees as contractual workers and to allow them to work under the respondent authorities as casual employees, casual Mazdurs, for which their names have been forwarded for regularization to their higher authority. However, no action has been taken in this regard by the authorities, although the nature of work performed by our applicants with effect from 1903 to July 2007, after they have been treated as contractual worker with effect from 27 remain the same. It may be stated that right from the day of their initial engagement as casual labor, your applicants have been working in various responsible fields like running single-headed exchange, maintenance, cash collection, planning section, computer works, etc. And that too in a difficult terrain, having lack of public transport. And this is now your lordship will see their verification at page 20 of the OA. Four point three, 4.4, 4.5, 4.6, 4.8, being matters of record of the case are true to my knowledge. They have derived their knowledge, I mean,
Knowledge from the record.
knowledge from the records. There must be at least, there should be a scrap of paper. And then our reply, your lordship may say. Paragraph 10,
202 of the affidavit filed by the. Or to be, or the affidavit filed by the college.
that with regard to the statements made in para 4.8 of the application, the answering respondents state that the allegation made in this paragraph and in Annexure 8 of the OA are misleading and baseless for the reasons as stated herein above. The 24 members of the casual laborers were engaged on full-time basis and they were being paid through acquaintance role of BSNL. However, as per the corporate office letter number so and so, the mode of payment of through acquaintance role has been stopped. It is further stated that BSNL has discontinued any part-time daily wages of casual basis engagement, including all the applicants after finalization of the tender for supply of contract labor on 20. Hence, the question of placing the applicants under contractor as contractual labor does not arise, as all the labor requirements are being supplied by the contractors. The respondents also state that the question of confinement of the temporary status and regularization is a matter to be dealt with within the strict parameter of the scheme of 1989, which is not an ongoing process.
Rather was a one time.
It was a one-time measure. Any other extraneous reasons like difficult terrain, etc., could not be attracted toward the provisions of the scheme, or it extended its benefit beyond the scope of the scheme. Any engagement of casual laborers at any point of time outside the scope given outlays under the said scheme would not attract any legal right to any such person to claim the regulation of commitment, conferment of temporary status.
Yes. File case 64 to Ahila will show that they will not be part of
And that, my lord,
the affidavit.
yes. নোট কপি করতে হবে নোট করানো Yes, so your lordship, that is why I say, my lord, that if I correctly understood, let there be a decision on the withdrawal and we placed it. Both will be on record, namely some document, because, my lord, we must have paid them that acquaintance role or whatever may be.
Mean to say that no casual labor without TSM status was remained with the BSNL at any point of time after 2007. Then what about this letter, page 325?
Yes, flashing as a light. Why is it flashing the light for the phone? ঠিক আছে. No, no, it is not that. Obviously তো আছে. They are regularly working. Later dated 17/7
Yes. Point number 3 or point number 2.
whether there are any casual laborer without TSM status who are still working in any circle, Arunachal Pradesh, who are being paid officially by BSNL.
Directly by the BSN.
Yes.
List enclosed A, annexure A.
Miller,
This is the list which includes the name of these persons apart from the name of the professionals, applicants.
continuously. Miller, these 24, they work all together, even today.
They were
These 24 employees,
20 employees, not 24.
when they work right from the beginning, even today.
They are working along with us only. Same office we work.
In
Yes.
fact, in our affidavit, Miller, we have explained it in more details. Reply.
I'll consider.
Miller, this our question. I again reiterate, Miller, if withdrawal is correct and if placement, their placement is at our instant, then we can't escape this liability.
From the
One more
record, it
thing.
appears.
One more thing, Miller. At one point of time, a client was thinking to give them some relief, but the contract, then this system, has- contract labor, this system has been withdrawn long back. Today, suppose, my lord, by judicial order, would be in great difficulty where to place them. They are not a skilled laborer. And then let them explain from 25, 24, 25 till 20, on what they were doing, where they were doing. Your lordship also put a question to me regarding letter dated 33/2004. Your lordship has got a copy of our affidavit.
Your affidavit,
Mr. Nath has supplied. Page 352.
352.
Yes. Page 352, Miller, Roman 3.
The one my copy I have is given, my lord. In that copy, lordship will get it. The one I have given.
Yes,
That the letter dated 33/2004, page 184 of the affidavit was merely a forwarding list of left out casual laborers for consideration of BSNL corporate office regarding their regularization. Now they have abandoned that, which contains the names of 39 respondents who were working as casual laborers with BSNL at that point of time. The said letter was only a request for regulation of the left out casual laborers without actually commenting on their eligibility towards regulation under the erstwhile dot scheme. It is needless to state that the private respondents have already given up their claims for TSM status and regularization. And the said letter doesn't have any relevance at this point. Then page, my lords. Next paragraph, 4. The Bhait letter dated 17/7/2023, page 325 of the affidavit. The BSNL had clarified the factual position to its counsel before the tribunal, and even casual laborers without TSM status are working BSN. The letter does not have any mention that the private respondents were disengaged. This fact does not give any credence to the claim of the respondent that they were disengaged. Thus, the said letter coupled with the letter dated 33/24 would not have been a ground for the learned tribunal to direct the BSNL to keep the present respondents as casual laborers under the BSN. The next paragraph will further explain, Miller. Page 353, that the private respondents were never withdrawn and placed under the contractor with effect from 27/2007, as has been sought to be projected by them. The private respondents at page 307 to 320 of the affidavit have brought on record part of the note sheets of the number A642, and in fact, the same proves the case of the writ petitioner that the private respondents were working under the BSNL till 2004-5, but not thereafter. A perusal of the note sheet would reveal that the private respondents were paid their productivity linked incentive till 2000-2005, as they had worked for 240 days per year up to 31/3/2000, as per the note sheet 4, page 310, the affidavit. However, for the period of 2005-2000, noting of NS6, page 312 of the affidavit, finds mention that the list of casual laborers, including TSM, as on 31/6, who have worked for at least 240 days during preceding 3 years, as mark A in 4C, may be furnished for payment of the bonus 2005 PLI, not eligible for part-time employees. Their names were not included there. The said letter dated and the list of casual laborers are marked as 4C in the file number. Further, in NS page 300, it is mentioned that it reveals from the document placed at 5C and 6C that the wages for 24 numbers of listed laborers have been paid through acquaintance roll for the month of January 2007. Details of staff have been placed at 5C. As these 24 numbers casual laborers have been listed and paid through the acquaintance roll bonus PLB to these casual laborers as applicable may be paid. The said list of FC and CISA are also available in file number A6. The next page, Miller. It may be relevant to mention herein that the note sheet NS6 and clearly indicate that the present respondents did not complete the requisite 240 working days for preceding 3 years, and as such, their names were not included in the said list for the year 2006, as they were not working as full-time casual laborers. The aforesaid documents go to show that the private respondents were not working under the BSNL during the period 2005-6 and 2006-7, and the said fact was not taken into consideration by the learned tribunal while passing the impugn order dated. Yes, here one point, the this file A642. Partly it was placed, Milord, and that thing was not placed before the tribunal.
Part of the note sheet.
Part of the note sheet. Now we have annexed here entire thing. So that clears our position. If any other queries are there, Milord, I am ready to do it.
My lord. Lordship will find 3 things in this particular case, 3 stands. Number 1, in paragraph page 19 of their petition, my lord, Lordship will find they've taken a stand, my lord, Let me read my lord. Page number 19, my lord, please. Page 19. Lordship has got it, page 19, my lord. In the middle, Honorable Tribunal had most illegally referred a different file number A642, and that too without any mention of the note sheet numbers in its order dated 4/8/23, based on mere false contest of the respondents, my lord. Now, my lord, Lordship may kindly come to page number 284. Lordship will get this order 4/8/23.
You know, that file will be 642, not 672.
4/8/23, the our gets last order, my lord. CAT order dated.
640.
That Lordship will get in page number 77.
77.
Yes, only 77 of their writ petition.
Yes.
Now, my lord, kindly see, this 642 has been mentioned by the CAT, my lord. Even the
This is
CAT, my
mention
lord,
of 672.
they are in the writ petition, my lord. Suddenly they say the Honorable Tribunal has called for file number A672. Actually, it's a typing mistake, my lord.
Yes.
No, typing mistake. Lordship dictates instead of 5/6, nothing else. This doesn't change or did not change the factual part, my lord. Why I am saying so? Please, Lordship may kindly come to order of the Honorable Tribunal, my lord. Lordship will find that, my lord. Page number 298, my lord.
Para.
298, my lord. In my my lord, my last day I filed it, the big one. 298. I'll show, my lord. There was never any mistake committed by calling for the files. 298.
Yes.
Lordship has got it?
Yes.
Last but one para. The respondents are directed to bring on records file number A642 NS126 by next date of hearing. Lordship has seen this, my lord. Previous one also refers to original documents in terms of the Honorable High Court's order dated. And that your Lordship's order in page number 284 of High Lordship's order earlier, my lord, the Chief Justice, my lord. There, this same file number is mentioned. 6A642, not 72. It's last moment were dictating. In the same judgment, even 642 is there. Only I think it's a just typical mistake, nothing else.
No, we agree to that. Yes. it is
Number
correct.
one. Now I'm coming to it, my lord. Now, this is one stand they've taken. The second stand they have taken in the repetition is that we have abandoned our job and gone to the contractor. That's the basic issue. Now, in page number 202 of my this big bunch, paragraph 10, Lordship has seen, my lord, kindly see. Lordship has seen number of times, my lord, this one, but once again, I'm just showing. Paragraph 10, page 202.
Yes.
It is further stated that in the middle, my lord.
Yeah.
It is further stated that BSNL has discontinued any part-time, daily wage, casual basis engagements, including all the applicants after finalization of tender of the contract labor on 2707. So this part will answer two things. Number one, so far the disengagement is concerned, it is their stand, they have started disengagement. Number one. Number two, the one I have, my copy I have given to Lordship, my lord. Please come to page number. I'm just giving the page number, my lord. 353, please. The one I have given, my copy. No, my copy I have given, my lord. On affidavit, the filed yesterday.
C5.
353,
353. Yeah.
page number. This paragraph 5, I think, 15, I think, my lord, that's para.
Yes.
Private respondents worked till 2004, 2005, and not thereafter. Lordship has seen that. That's marking, I think. Now, your lordship has seen in WS, paragraph 10. What is the statement? Absolutely contradictory. BSNL has discontinued any part-time, daily wage, casual basis engagements, including all the applicants after finalization of tender for supply of contract labor on 2707. Those are not correct statement. Not only here, another place, their own statement documents, my lord. Now please come to 130 of their second affidavit. After the petition, the file the second petition, my lord. Affidavit, this one, small one. Second one affidavit they filed. They filed on 16/7/2004. 24.
Page.
138. Now can you see here? My lord, fifth line, 1, 2, 3, 4, 5, sixth line, my lord, from top. My lord, or fourth line. It is an admitted fact that, lordship has got it, my lord. Fourth line, it is admitted fact that they have been working under contractors since 2007. But it is also a fact that BSNL had never placed the respondent under the contractor as contained by the respondents. Next line is important. In fact, the respondent has themselves abandoned their work as casual laborer in BSNL way back in 2007. Lordship has seen, my lord. Their own statement 2007 we left it. Now in this particular paragraph, Roman 5, what they're saying, after 2004 and 5 we are not there. Contradictory statements, my lord. Absolutely.
Yes.
So there are three issues now from all these documents I find. One is file number wrongly called, wrongly decided, and Lordship Honorable Tribunal has repeatedly asked for the file number in the order sheets are there. I have annexed in my this big bunch, my lord, orders. They've not done it, my lord. The second point is, my lord, disengagement. We have go of our own, where we are getting the salary of around 15, 20 or 10,000 orders there, my lord. Who is that person on this earth who leave the government job and go under contractor? Who is that person, my lord? I don't think anybody is born like that, unless that man is insane, my lord. Nobody. Third is, the submission is that from the note sheet A642, 4642, the note sheet says, till 2004, we are working there. But here, lordship, in two places I have shown in their affidavit also, my lord. Till 2007 we are working, my lord. Which is correct? Which statement will lordship take them as a trustworthy, my lord? It is the officials, my lord. While briefing my friends, I think, my lord, I'm not saying the senior, they prepared it. I think they purposely, my lord, to misguide so that we don't get that minimum relief of getting just 2 square meal a day. That's all, my lord.
Sorry. Yes, something else?
My lord, we have annexed the entire file. In our affidavit.
Yes,
We have annexed the entire file, my lord, your lordship. Beyond that date also see the note sheets.
Yeah.
And my learned friend is pointing out regarding the part-time engagement and full engagement. Part-time engagement entirely different thing. Full engagement is entirely different.
My lord, can I just say one thing, my lord? In paragraph 10 of their WS, my lord, lordship is read, my lord. Just I want to point out one thing. That BSNL discontinued any part-time, daily wage, casual basis engagement, including all. I have given chart, my lord. I have given chart, lordship will get, my lord, that chart in page number 239. Lordship will get a chart. I have given the charts. Who are the persons appointed in 93, 94, 96? That chart I have given. We 24 persons from Arunachal Pradesh. Now 20 are there. They are working this side. That chart. We 52, our chart, and 150 from Nagaland, and that chart I have given. All of them are working, except we have given that, my lord. Page number 230 and 40, my lord. Lordship can note that.
30 and 43. No, my case is wasn't that they have left. They may be part-time, that is a different thing altogether, but their case is not that. 240 days they have to do that within the 3 years. Now, one basic question your lordship will see. After 2005, where they were, 2006 and 7?
You yourself has admitted in the petition itself that they were disengaged in the year 2007. So they were with you only, or where they were
No. Why they are not agitated?
agitated, that's all. Yes,
So that is another aspect, my lord, 2006, 7, where they were. And why did OA comes at 2009? After long 4 or 5 years.
No. 2 years. 2 years we've had representations. And the last one we annexed in the way, my lord, last page. The copy, lord, you will get it. here, my lord.
the tribunal has noted this.
Yes.
Tribunal.
Even
It's also, that's all.
One more aspect, my lord, if they were disengagement like this like that, they ought to have approached the industrial division. Raise the industrial dispute. I think I am clear, my lord, your queries, your lordship's queries.
On 16/8/2024, this court has granted time to the counsel for the PSN to complete the instructions as to whether the PSN may be ready to keep the applicant's response herein under its control instead of a contractor. Stop. An additional affidavit is filed on behalf of the BSNL claiming that the applicants, respondents were disengaged way back in the year 2004-5, and thereafter they were not, but 2004 and 5 on their own and joined the contractor. Full stop. From the tenor of the affidavit, it appears that the respondent BSNL is not ready to keep the applicant respondents here in under its control. Faced with this situation, with the consent of the parties, we have heard the matter finally. Arguments concluded, judgment reserved.
deeply obliged.
Obliged.
Item number 2.
May it please, your lordship. Well, this matter relates to drilling in the national park.
The Supreme Court held.
Yes, my lord, our information is still pending. But in the meantime, another development has taken place which has got bearing with this case. In July of 2024, the Forest Advisory Committee of the central government took a decision to reject this proposal on the ground that the Supreme Court's 2023 order has now laid down the law as regards eco-sensitive zone. 10 kilometers if not extended, if not notified, if notified, no mining within 1 kilometer. So that's the law.
Now what remains in this?
So what I
Once they have already rejected that proposal.
Malad, we have challenged two issues.
Yeah.
First is the issue of this mining. Because biodiversity test was not done in terms of Supreme Court's order. The second was that the EIA, the Environment and Impact Assessment, then a notification came which shifted public hearing from A category to B category, and B category is a lesser form of mitigation. So we challenge this on some legal grounds. So that issue remains. What I propose, Lordship, can the central government give their affidavit on this point? Because it is in the public domain.
Information you supply us.
Malad, the information only problem is that we got it in the newspaper, but the second part is not there. So I don't want to give it, but I'll just place this. The second page we could not trace out. Mr. Chaudhary was it?
Again, concept of the impeachment, I submitted that no, the matter, though the issue, though a similar issue is pending before the Honorable Supreme Court till date, however, from the newspaper reports,
In the
it
Sentinel.
appears that the Union Ministry of Environment, Forest and Climate Change has rejected the proposal for extended reach drilling in bracket ERD inside Dibru Saikova National Park. Full stop. Is submitted that the said news is published when it
Well, on 5th of August
on 5th of August 2024.
in the Sentinel paper.
Taking into consideration the above fact, we direct the council for the central government to clarify whether the Union Ministry of Environment, Forest and Climate Change has rejected a proposal for extended reach drilling ERD inside Ibru Saikova National Park. And with any such decision, the same be placed on record. On that purpose, 4 weeks' time is granted to the concept of the central government.
Right, obliged.
Item 3.
Respondent number 1 has not been served till date, sir.
Lordship, I may be allowed to take fresh step by way of dusting.
As per the office report, the notices issued to the respondent number 1 has not been served till date. Then the counsel for the petitioner appellant is directed to take fresh step for issuance of notice to the respondent number 1 through Dusty mode. The requisites be filed within a period of 3 days on filing of the same. That notices be issued to the respondent number 1, returnable 4 weeks thereafter.
Item 4.
Office dated 16/8/2024,
Respondent number 4.
4. And Lordship, the name, standing counsel of GAD has not been shown in the cause list. I have personally informed him, but he said my name has not been shown in the cause list.
Who?
GAD, Lordship.
The respondent number 4 is the GAD.
No, private respondent is 4, Lordship. And
Private
GAD is, Lordship, respondent number 1, Lordship.
And who are the respondent number 2 and 3?
2 and 3, Lordship, the government.
Okay, respondent number 1 is GAD.
GAD, Lordship.
Who is the counsel for GAD?
Mr. A. Fukan.
Fukan.
Okay. As per the office report, notices issued to the respondent number 4 has not been, the notices issued to the respondent number 4 be awaited for 3 more weeks. List after 3 weeks, while reflecting the name of Mr. A. Funkan as counsel for the respondent number 1.
Item 5.
Obliged.
Madam, respondent number 6, notices have not been served.
Yeah.
Await return of notices for respondent number 6. Await return of notices for 3 more weeks for respondent number 6.
Item 6.
Let I file the affidavit today.
On behalf of
Sole respondent.
sole respondent, Mr. So-and-so, is appearing on behalf of the respondent number 1 and has submitted that an affidavit in opposition has already been filed on behalf of the respondent number 1. This matter for admission after 2 weeks.
Right.
Item 7.
May I please, your lordship, matter may be passed on for the time being, lordship.
Yeah.
Time being, lordship.
Respondent number 5 is still not served.
Lordship,
Respondent number 5 is not served.
We will serve lordship. We will serve.
We'll await notices for the respondent number 5 for 3 more weeks. Await return of notices of respondent number 5 for 3 more weeks.
Noted.
Item 8.
My lord, the I is for prayer to condone delay of 5 days in filing the appeal.
50 days.
5 days, my lord.
No, 55.
Item number 8, 50 days, sir. Not 5,
50 days.
I'm sorry.
50 days. Yeah.
I have no objection. Let it come for admission
Okay,
here.
the matter comes upon for consideration of the application, IA number so and so preferred on behalf of the applicant with the prayer to condone the delay of 50 days in filing the connected appeal. When counsel appearing for the sole respondent, there is no objection if the delay is condoned, hence the IA is allowed. If the delay of 50 days in filing the connected appeal is condoned, the registry is directed to register the connected appeal and list it for admission after 3 weeks.
Any day.
Lordship,
Copy
can
of
it
the
be a
writ
little
appeal-
early?
Copy of the writ appeal be supplied to the.
It is already served. It is already. Can it be after 2 weeks, Lordship? Because
After 2 weeks,
deeply obliged.
while reflecting the name of Acha already is there.
Already. Obliged.
Item 9.
My lord, there is a delay of about 128 days,
21 days.
28. My lord, according. Yes, please stick on the. 28. Iman. One more time.
Count করান আপনি 120
ST price.
Yes, ma'am.
Okay.
You are referring on behalf of all
Yes,
the respondents.
yes, sir.
All the respondents.
All the respondents.
Question Deba.
The matter comes up for the consideration of the IA number 2483 of 2024 preferred on behalf of the applicant with the prayer to condone the delay of 121 days in filing the connected appeal. And a counsel appearing for the for all respondents has no objection if the delay is condoned. Having heard the learned counsel for the parties and after going through the contents of the application, we deem it appropriate to condone the delay of 121 days in filing the connected appeal. Hence, the IA is allowed. Delay of 121 days is condoned in filing the connected appeal is condoned. Registry is directed to register the connected appeal and list for admission.
My lord, on any days after 12, my lord.
Third week. Third week of September.
My lord. Obliged.
Item 10.
Three fifty, 43 days,
Losses,
mostly here.
appeal is by the third party. Lordships,
Relax.
because I have badly affected by the judgment and order passed by the single judge.
What's the judgment in order? You were party before the London single judge. You were party in the writ court.
No,
You were not party.
I am not party.
Then where is the application seeking leave to file appeal?
I have filed I also.
Where is that?
That is 25222. IA.
Where is that? Just a minute.
Main fact is, Lordships,
Just. How you are going to be affected by this order?
Lordships,
How you are going to be affected by this order of the learned single judge?
Lordships, as per 90 CPC, Lordships, and Supreme Court judgment of here, citation
Here,
regarding that third party can file appeal.
how you are aggrieved? Yes, you can file an appeal and we can very well grant the leave. But how you are affected by this impugned order passed by the learned single judge on 31st of July 2023?
Lordships, I am the owner of the land.
Or it may be the other party has only sought demarcation of the land. If the demarcation is done, who is the owner, who is not the owner will be clarified.
Yes, Lord.
How you are going to be affected
But
by
land-
this order?
Land is mine, but other person who is not belong to that land, he has filed an petition, application here, read petition, and it was filed on 24 and without being issued any notice, 31st, it was disposed of
Is
on
there
motion,
Is there
without
any-
being giving.
Is there any bar under the law that after filing of the writ petition, the same can't be disposed of within a so and so period?
And the whatever mutation was done without giving any notice to the other
Mutation,
party.
sir. Challenge that mutation.
Already been filed.
Then what remains in this?
That has been already been filed.
So this demarcation.
But now,
Just a minute, sir. Please listen. This pursuant to this order, this demarcation proceedings has already been completed.
yet to be completed.
Yet
So
to be
stay order is required. Stay order is required to stay the execution of the order passed by the single judge.
For what? Stay
Be-
order for
Because
what?
I am affecting
You are affecting.
and
then
aggrieved
approach-
by the judge, by the order of the single judge.
Then approach the authorities concerned if you are aggrieved.
Yes, already been approached.
You have already approached.
Approached.
Because
And annexer also here.
Learned single judge has granted a liberty and observed that it is needless to state that affected parties are to be given opportunity of hearing before passing final orders. Any final order is passed,
No order is passed.
then
Yet.
what remains? And you have approached the
Is
authorities.
pending, that petition is pending there. No date is given.
Huh?
Earlier, 2 date given, now no date is given, that is postponed. Adjourned till date. So may direct to consider the petition, that is, Lordships, I have.
Yes.
That is 69 page, 23 to 2024,
Yes.
annexer N,
Yes.
69.
Lecture M. In which application?
That is application to the circle officer, Nalbari Revenue Circle.
Annexure M attached to which application here? 2521 or 2522?
232, 2024. Lordship page 69, Lordship. Very slow one.
Yes, annexure M.
An application for mutation of names of Anjana Bose, wife, Sangita Bose, daughter, and Nandita Bose, daughter of late Shamal Bose. with due respect, I would like to report to you that I am legally married wife of Les Shamal Bosch, and he had 2 daughters, as cited above. Our names are not to be mutated in the plot of land measuring 20 bighas, covered by dark number so and patta number 52. Situated at village Shoriotoli, Moja, Batagila in the district of Nalbari, Assam, by virtue of inheritance, in place of late Shamal Bosch, son of late Saraswati Pada Bosch. It is seen some other names are mutated in place of late Shamal Bosch, whose names are required to be deleted from the Jamanbandi by way of rectification.
Yes.
Lordship, one thing, Lordship. Respondent of one Kalpana Bosu, no way related. He is not a legal here at all. His name is mutated.
That's all. The matter comes upon for consideration of the application number 2521/2024 and IAS number applications number 2521/2024 and 2522/2024. The IA number 252, in IA number 2521, counsel for the applicant has prayed for condonation of prayed for condoning the delay of 343 days in filing the appeal against the order dated 31/7/2023 passed by the learned single judge in WPC number 4284/2023. The IA number 2522/2024 is preferred on behalf of the applicant seeking leave to file appeal against the order dated 31/7/2023 passed in WPC number 4284/2023. Full stop. the non-applicant Kalpana Das Barua, Basu. Kalpana, the non-applicants Kalpana Das Basu and others have filed writ petition number 4284/2020. Only one he has. Petitioner only, there was only one petitioner.
Only one petitioner. আমরা তিনি
Yes. Non-applicant number one. Kalpana Das Basu has filed a petition number 4284/2023 before the writ court, claiming that she is the owner and she is the owner and possessor of a plot measuring about 24 bighas covered by Doug 112, 123, 116, 117, 122, 110, 124, 125, 129, 170 of KP Patta number 52 of village Sariahatli under Moza
Potagila.
Batabugi district Bataguli district Nalbari. The grievance raised by the non-applicant Kalpana Dev Basu was that though she has approached the authorities concerned for demarcation of the said plot because some unknown persons are trying to encroach over her land, but her application was not considered and the land of the demarcation and the demarcation of the land could not take place. Could stop. The learned single judge has disposed of the writ petition, directing the petitioner Kalpana Dev Basu to furnish all necessary documents and format for exercising the for demarcation of the land concerned with a further direction to the authorities to do the same within a period of within a period of 2 months. The learned single judge has further observed that it is needless to state that affected parties are to be given opportunity of hearing before passing final orders. Para. Learned counsel for the applicant has submitted that as a matter of fact, with the order passed by the learned single judge, the rights of the applicant are going to be affected affected because he is the real owner of the land concerned. Full stop. Is submitted that the learned single judge without hearing the affected parties as passed the following or passed the interim order. So learned counsel has therefore prayed that the prayed that leave be granted to the applicants for challenging the impugned order passed by the learned single judge and the delay in filing the connected writ appeal against the impugned order be also be condoned. Having heard the learned counsel for the petitioner and after taking into consideration the fact that till date the demarcation proceedings have not been finalized pursuant to the order passed by this court, we are of the view that in view of the observation made by the learned single judge that the affected parties are to be heard before passing the final orders, the responding authorities responsible for demarcation of the concerned land are required to hear the affected parties if any, including the petition, including the applicant. Hence, if the petitioner, if the applicant has already approached the concerned authorities in those demarcation proceedings, it is expected that the authorities concerned shall pass the final orders after hearing the applicants, after providing opportunity of hearing to the applicants. Will stop. In view of the above fact and circumstances, we don't find any case for condoning the delay or condoning the delay in filing the connected appeal and granting leave to the applicants to challenge the impugned order passed by the learned single judge. Hence, the IA number 2521/2024 and IA number 2522/2024 are disposed of with the above referred observations. Resultantly, the connected appeal number resultantly, the writ appeal number 9028/2024 filing number is also disposed of.
For admission, item 11 and 12.
Lordship, the value of the appeal is below the litigation policy. The value of the appeal is less than 1 crore.
Yeah.
So Lordship, in other appeal, Lordship may
You
dispose of
already
the,
observed
yes, Lordship,
that the question of law
will be kept open.
the CTET has also dismissed that.
No,
on this now.
they dismiss the appeal on the merit. Lordship.
Okay. Where is the new notification?
Lordship,
This is.
Nothing. 24.
In all these appeals?
Two,
the-
11, 12 Lordship. 13 is
11 and
also,
12.
but 13 Lordship, the matter relating to seizure of gold.
I've been taking into consideration the fact that the amount involved in this, in these present cases is below the monetary limit of rupees 1 crore.
1 crore Lordship. Right.
1 crore, which has been notified by the board's instructions dated 2/11/2023. 2/11/2023.
Subsequently, Lordship, another notification is there. That is mentioned in this order law. 24.
Another notification.
This is previous one. Lordship. In the order I have given Lordship, that that is mentioned. Lordship.
26/6/2024.
Lordship.
Which has been notified by the board board instructions dated 26/6/2024. Hence, the appeals are dismissed under national litigation policy. However, the question of law raised in this appeal, in these appeals is left open for the appropriate decision in appropriate cases,
My lord,
in appropriate case.
my lord. My lord, in this matter, my lord, there is no stay, my lord. Until now, department has not paid anything, my
Madam, we
lord.
have already dismissed it.
My lord.
Now you
My lord,
take your own.
obliged.
11 and 12 both?
Lordship.
And what about 13?
Lordship 13, in this case, Lordship, gold was seized. However, the value is less than litigation policy.
Then
But Lordship, here, what even that CSET says that the purity of gold was that taken into consideration, right? Under section 123, there is the burden of the person to.
even though there is a question of law, but once the monetary limit is less than that, then we'll keep it open for you to raise this point in appropriate.
Lordship, I am not disputing that, but Lordship, the question of law is very important to be decided by Lordship.
So, in an important case, we'll decide it, where the monetary limit will be high.
Here, Lordship, what there were two seizure. One is it 6,000 grams of gold.
Same order.
No.
तीनों के अलग-अलग orders, separate orders.
This,
Same order.
is not, this appeal.
This appeal, these की जगह this appeal and
This is
three
different.
orders, separate orders. Same order.
Yes. Item 15.
Made please worship. My lord, background of the case is this, my lord. Actually, my service was provincialized. But the respondent number one, my lord, he challenged my provincialization. And ultimately, learned single judge referred the matter to the director. So director is to take decision. So director was pleased to take a decision. And what happened, my lord, against the order of the director,
Again, did.
my friend was aggrieved and filed a statutory appeal before the state government. During pendency of this appeal, my lord, they approached this honorable court, my lord. And learned single judge, during pendency of the statutory appeal, passed the impugned order. And by that impugned order, my lord, I am agree.
This is the only ground.
My lord,
This is the
another
only
ground,
ground.
my lord,
That since the appeal was pending and in the meantime, the learned single judge has decided the rate petition, this is the
pass
only
this.
ground.
No, my lord, other ground is there.
Yeah.
My lord, your lordship would be pleased to see the position of law, my lord. That in the director's order, it is held that I am senior by 1 year. I am senior by 1 year than the private respondent number one. Now what happened, my lord? The learned single judge deciding the issue want to say that as per law has been cited by the learned single judge. Your lordship would be pleased to see.
Learned single judge has simply remanded the matter or referred back matter to the director with the direction
To reconsider.
to reconsider as per the direction given on in the year 2022, precisely on
By the
27/1,
by the learned
2020.
single judge.
Yes.
That all right, my lord. Your lordship would be pleased to see whether the learned single judge rightly done this. Because, my lord, your lordship would be pleased to see the order of the director. What wrong has been committed by the director?
First of all, you satisfy what are the direction by this court, by the order dated 27th of January 2022. What directions were passed by the learned single judge in that writ petition number 2493/2021?
Hello,
What are those directions?
my lord.
2493/2021. What directions were passed at that time?
That direction was that you looked into the matter, entire matter, and take a decision.
Please
My lord.
refer to that order.
My lord, let us see the order, my lord.
Yes,
Order of the learned director.
not director.
My lord.
The earlier order passed by the court in writ petition number 2943/2021.
Earlier writ petition.
Yes.
Yes, my
Page
lord.
74.
Page 74. It starts from 77, my lord.
77.
Yes.
Yes.
Heard Mr. A.R. Bhuyan, learned counsel for the petitioner. Also heard Mr. P.K. Bora, learned standing counsel for elementary education department, representing respondent number.
Para number 2, sir.
Para number, my lord. Para 2.
Or come to para number 3. State.
Yes, the case of the petitioner is that pursuant to appointment order dated 10/11/2006, the petitioner joined second assistant teacher of so-and-so ME Madrasa on 14/11/2006, which is under administrative control of Block Elementary Education Officer, Lakhimpur in Golpara district, hereinafter referred as to BEO for short. The said madrasa was allotted District Information System Education DICE for short. Code in the year 2006. The name of the petitioner was entered in DICE data with effect from the academic year 2008-9 and second assistant teacher as said ME Madrasa. It is claimed that on registration of the previous headmaster, resignation of previous headmaster, the then managing committee of the said ME Madrasa appointed the respondent number 9. He is the appellant before your lordship as the headmaster on 9/8/2009, and accordingly he joined as headmaster of the school on 11/8/2009. No, my lord, this is wrong, my lord. This is wrong. It is in 2005. I joined as headmaster in 2005, and that his name was entered into DICE data for academic year. Accordingly, it is claimed that the respondent number 9 was junior to petitioner. It was also projected that the
Come to para number 13 directly.
13. As indicated herein before, highly disputed question of fact has arisen in this case. Hence, the court is of the considered opinion that the state issue relating to the claim of provincialization of service of A. Hanifuddin petitioner and Abu Saleh Sharif Uddin, respondent number 9, he be relegated to be decided by the Director of Elementary Education Assam, respondent number 3, for a fresh examination and determination by considering all the relevant material. It is also desirable that while deciding the matter, the respondent number 3 would also examine the qualification of petitioner and respondent number 9 as well as the records of District Scrutiny Committee Golpara DSC to find out on what basis their recommendation had been made. The Director Elementary Education Assam shall also ascertain why an inquiry came to be conducted by the Assistant Commissioner and whether follow-up action, if any, was taken after inquiry report was submitted before the Additional Deputy Commissioner Goalpara by letter dated so and so, recommending that the matter be placed before DSC for re-verification and necessary action. Subject to COVID-19 protocol in force from time to time, the Director Elementary Education Elementary Education Assam shall make an endeavor to determine the dispose of the claim of the petitioner for provincialization of his service in vis-a-vis the respondent number 9 within a period of 2 months. From that the date of service with a certified copy of the order before the office of the respondent number 3. The petitioner as well as the respondent number 3 are given liberty to forward the respondent number 3 any documents they intended to rely upon, which shall be done within a period of 10 days. The petitioner and the respondent number 9 are not granted liberty to submit any write-up, summary, or any argumentative points, which if it is still filed may be discarded, as the matter would be decided on the basis of documents. No opportunity of personal hearing is required. If any of the parties are still aggrieved, the aggrieved party shall be at liberty to file statutory appeal provided for, as narrated herein before the claim made by the
Leave this.
respondent.
Now, where is the decision of the director?
Yes, ma'am. And listen. Director, session. 192. Yes, 192, my lord.
What?
192.
Yes.
The Honorable High Court's order dated 27/1/22 in IA Civil Abu Saleh Sharifuddin linked case so and so Hanifuddin versus State of Assam. Reads the Assam Education Provincialization Service of Teachers Reorganization Educational Institution Act 2017. A report submitted by District Elementary Education Officer Golpara by letter dated so and so. Inquiry report dated 6/10/2022 of ADC Golpara. Representation dated 4/2/2022, 13/6/2022 as submitted by Hanifuddin. Findings. Petitioner Hanifuddin was appointed by SMC as assistant teacher of so-and-so MEM under Lokhipur Education Block of Golpara District. The petitioner is challenging the provincialization of service of Abu Saleh Sharifuddin as well as recommendation of DSC Golpara for provincialization as illegal. DEO Golpara has submitted report by letter dated 28/2022 that Hanifuddin was appointed as assistant teacher of so-and-so MEM Madrasa by SMC on 10/11/2006. by SMC resolution number 10 dated 10/11/2006, and he joined in the school on 14/11/2006. DEO Golpara also stated that Abi Saleh Sharifuddin was appointed as headmaster by SMC of MEM on 30/5/2005. Here, your lordship will consider the seniority about 1 year by resolution number 2, and he joined the school on 1/6/2005. As reported by District Elementary Education Officer Golpara, the appointment letter of Hanifuddin was issued by Abu Saleh Sharifuddin. My lord, Hanif's appointment letter was issued by Abu Saleh Sharifuddin, the appellant, headmaster on 10/11/2006, and received the joining letter of Hanifuddin by Abu Saleh Sharifuddin on 14/11/2006. I issued the appointment letter, my lord. I accepted his joining. Now what happened, my lord? He is challenging that I am junior to him. As per inquiry report of Assistant Commissioner, Gwalpara, dated 16/10/2020, name of Hanibuddin 80 has appeared in all dice code from 2009-10 to 2017-18, whereas name of Abu Saleh Sharifuddin, headmaster, has appeared in the dice code from 2011-12, 2017-18. It is to be mentioned that as per clause 2Z of the Provincialization Act 2017, Bansar Upper Primary School means a school imparting education from class 6 to 8 and established by the people of the locality prior to 1/1/2006, which has received recognition from competent authority on or before 1/1/2006 and captured in Dice Code 2009-10, and whereof the services of teachers have not been provincialized under any act enacted by the state legislature so far. As per provision of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017, the DEO Golpara has submitted the proposal for provincialization of service of the following teachers of so-and-so MEM, and the DEE Assam placed the said proposal before the SLC, SLSC, and the joint committee constituted by government for verification of proposals. So these are the teachers' name, my lord. I am Abu Saleh Sharifuddin in the second position. Social study. The government of Elementary Education Department has committed a joint committee to examine the proposal for provincialization of services of teachers of VLP and RUP schools with chairmanship of RC Zone IAS retired by notification number so-and-so 18/3/2019. As per minute of the meeting dated meeting held on 24/7/2020, the joint committee decided to verify the following parameters of DICE data maintained by NUEPA New Delhi of the proposed school as per the Provincialization of Services Act 2017. Whether the name of school appears in DICE data 2009 or before. Whether the name of incumbent appeared in DICE data 2011 and afterwards. Enrollment position of the school during 2016-17, 2017 and 18. As per instruct of the joint committee, by minute dated 24/7/2020, the SSA Assam submitted a DICE verification report in which the DICE code maintained by NUEPA New Delhi Kushagata MEM school, and it is found that the name of Abu Saleh Sharifuddin, respondent number 9, is available in DICE data. Accordingly, SLSC as well as
You are applying for the private school,
Malam, I am for the Malam,
red petitioner,
red petitioner. Hanifuddin Malam.
What's wrong in the order of the director?
My lord, may I draw my lordship's attention, my lord, to the paragraph, page 85, para 11, the learned single judge, my lord. First round, page 85, my lord.
85.
My
Yes.
my lord, I am reading paragraph 11, my lord.
Yeah.
It appears that the petitioner has been able to make out a strong prima facie case for continuation of the ad interim order dated 27/9/2021 passed in this writ petition, because although the respondent number 9 claims to have been appointed as headmaster on 1/6/2005, but the name of the respondent number 9 was entered for the first time in the DICE data for the academic year 2011-12 as on 30/9/2011. After the alleged appointment of the petitioner, the first opportunity to provide particulars of the petitioner in the DICE data was on 30/09/2006. Hence, the absence of submission of particulars of the petitioner in the DICE data leads to a strong presumption that the respondent number 9 was not serving the said madrasa as headmaster as on 30/09/2006. Moreover, To support his contention, the petitioner has also produced an affidavit sworn by the then president of the managing committee of the said madrasa that during his tenure, the respondent number 9 was not appointed as the headmaster. It is difficult for the court to envisage a situation where a dais data is submitted in respect of academic year 2006-7 to 2010-11 without correct name of headmaster being reflected. Therefore, as it unlikely that the respondent number 9 would forget to enter his own name in the dais data and allow previous incumbent's name to be entered in the dais data of the academic year 2006-2007 to 2010-2011, and thereafter wake up only on 30/9/2011 to enter his own name as headmaster. The respondent number 9 further claimed that on 26/5/2005, Habibur Rahman, the then headmaster of the school, had resigned on 30/5/2005. White resolution number 2, the managing committee of the madrasa had purportedly authorized the secretary of the madrasa to appoint the respondent number 9 as headmaster, which is not at all believable because when Habibur Rahman had resigned as headmaster on 26/5/2005, he had also lost his power and authority to act as secretary of the managing committee of the state madrasa. As indicated herein before, highly disputed. So, my lord, these are the two findings which has the learned single judge has held, my lord, that there is no existence of the present appellant at that relevant period of time as he has claimed.
But in the director's order,
My lord,
they have referred to a appointment order of 2005,
My
even
lord.
indicating that your appointment was made by him.
my lord, that some pleading has not been brought on record by my respected senior friend, my lord, which we have clarified before the learned single judge. The appointment, my lord, which has been demonstrated as has been issued by him to me, my lord, is a manufactured document, my lord. That's why, my lord,
Only the matter was referred to the.
that's why, my lord, yes, my lord, that's why the learned single
But-
judge has referred the matter
But
and they,
verifying from the record,
yes,
the
my lord.
director education has come to the conclusion that his appointment was prior to you.
No, my lord, that is, my lord, that's why, my lord, these directors, the contention of the learned single judge regarding the dais data is missing in the director's order also, my lord.
So
That-
even though if a person
My lord,
was working as a headmaster and in the DIAS data, his name is not appeared, how can we say he was not in the service at all?
exactly, because, my lord, as per the statutory prescription of the, my lord, 2017 Act, if my lord may be pleased to take up the position of the, my lord, what the dais data means is, my lord, if my lord may be pleased to take up page 107 of this manual, my lord. Because, my lord, it is clearly says that this person's name who is claiming provincialization under the Act of 2017, his name ought to have included on 2009 and 10. And, my lord, if we presume that his name, he was appointed in the year 2005, then, my lord, the proposition or the provision for incorporating the dais data starts from the year 2006 and 7.
Mr. Bhuya,
My lord.
this non-mentioning of the, non-inclusion of his name in the dais
My
data
lord,
raises a strong presumption.
my lord,
But this presumption has been displaced by the director in his order,
my lord.
where facts have been recorded as to who was appointed when, and therefore the seniority was determined on that basis. So merely because the learned single judge has expressed some doubt and some presumptions were following, that will not displace the finding of the director, which was done on a fact-finding mode.
My lord,
So what is wrong with the order of the
the
director?
inquiry report, my lord, which has been done by the additional deputy commissioner, my lord, had also reflect the same, my lord. Regarding the, that's why, my lord, the fact finding which has been done by the director, my lord, is not on correct perspective, my lord. The appointment order which he has been relied on, my lord, is also not in existence, my lord. It is a manufacture which we have contended in our first round of writ petition, my lord.
It's a manufactured document.
Manufactured
Have you
one.
lodged an FIR?
No, my lord, we have not lost an FIR, but the problem is that, my lord, the learned single judge, my lord, while adjudicating, has taken all these grounds, my lord, and that's why it had been referred. But those points, my lord, which has been, the finding of the learned single judge has not been incorporated in the order of the director, my lord. Regarding the dais data, my lord, the statutory prescription which is there, Now the director cannot override the statutory prescription, my lord.
No, but there was a joint committee report.
My lord, my lord, may kindly see
There was a joint committee report.
huh? No, my lord, there is no
Reference of which is made in the director's order.
no, my lord, there is no provision for the joint committee in the
Sir,
statute
in
also,
fact,
my lord.
The provision, but the learned single judges directed them to consider the same.
No, no, learned single judge is directed, my lord, if my lord may be pleased to peruse the order of the learned single judge, my lord, I am troubling my lordship again with the order, my lord, is at page 74, my lord. My lord, from paragraph 13 at page 85, my lord, I am reading it. As indicated herein before, may I read, my lord? Undo. Page number 111, or a page. Number.
Who is working now?
My lord,
My lord, I was appointed, my survey, my salary has been stopped, my lord, but I am working.
Salary has been stopped by whom? When you were appointed?
My lord, first they came before the honorable court after my
There
provincialization.
was interim
Then
order.
salary was stopped.
Yeah.
Salary was stopped, my lord. After the decision of the director, my lord, my salary was released. And
Fine.
thereafter, my lord, when Lalit Singhal Judge again interfered with the matter, my lord, my salary stopped, my lord. My salary is not paid. It stopped from the date of order by
But
the,
still you are working.
yes, my lord, I am working.
my lord, may I pray to draw my lordship's attention to the learned single judge in the second round of writ petition, my lord, at page 211, my lord. Kindly have a lord. Paragraph 22, my lord. Page 211.
Yeah.
As per the report of the Assistant Commissioner Gwalpara dated 16/10/2020 annexed 8 to this petition, name of the petitioner was recorded in the Dias Code of the State Madrasa from 2009-10 whereas the name of the respondent number 9 was recorded in the Dias Code of the State Madrasa from 2011-12. As per Section 2J of the State Act of 2017 Act, an employee in a venture educational institution have to join his or service prior to the year 2011, that is by 31/12/2010. Whereas the name of the respondent number 9 was shown in the Dias data of the said madrasa only.
Because his name was not in the DIAS data, but
My lord.
thereafter a joint venture committee
My lord.
find that his name was there in the DIAS data and thereafter they recommended for provincialization. How the court can?
No, my lord, they stated a prescription which is there, my lord. He is required to challenge that, challenge the same, my lord. He has not challenged, my lord.
Yes, what do you want to
My
say,
lord.
Mr. State Counsel?
We have found that the appellant was in fact working. He was appointed in the year 2005. Therefore, he was senior to the respondent. And that is how we again gave an order in his
Why his
favor.
name was not reflected in this DIAS data?
DIAS data reflection, he states that that part personally, I hear, I am not being able to fathom why he as a headmaster could not get his name included in the DIAS data. But then other documents show that he was there. There were similar other cases, which were disposed of by the learned single judge asking us to make a verification because at times DIAS data missed the actual particulars. There also we found that people were actually working, but somehow names were missed in the DIAS data. Otherwise, he being the headmaster should have had his name incorporated. That is one aspect of the matter. It was he who furnished the
We have
particulars.
heard the learned concept of the parties. Matter requires consideration, hence admit no need to issue notice as parties are represented in the concept. However, till the disposal of this status quo as it exists today shall be maintained.
Item 16.
My lord, regarding my salary, my lord, I will file an application. Obligation.
You are free.
I know.
Whatever.
My lord, the judgment input in this appeal lordship has been challenged in another appeal lordship that has been admitted lordship. My lord, the appeal is, my lord, 324 of 2023. That has been admitted by order dated.
Against the same order,
Yes, lord.
against the very same order.
Yes, very similar. However, my lord, this repetition they filed while the another repetition was getting delayed, para 12 of the repetition. That therefore the members, they have
Delay.
separately filed this repetition.
Delay has been.
That similar issue is there will admit.
Yes,
That is a ground for.
otherwise, my lord, section 18, my lord, any settlement.
Admit single judge will
Yes,
break with it.
yes.
But since if similar appeal is already admitted, then
Right.
separate demands which should indicate. And consent to the appellant has submitted that. Writ appeal number
324 of 2023.
324 of 2023 challenging the same impugned order is already admitted.
Lord.
Hence, admit no need to issue notice as respondents are represented
My lord,
through
for respond number 2, my lord, I make it.
all the respondents, not all
Union of India, my lord, respond number 1, my lord.
respondents are represented
My
through the respective concerts. List in due course along with writ appeal number 324 of 2023.
Lord, my.
Item 18.
Thus, the present appeal arises out of disciplinary proceedings initiated against two delinquent employees for having passed off undamaged. There was an e-auction for burnt cables which had been burnt in a fire which had taken in my premises. Burnt and damaged cables, my lords, were e-auction. But in the garb of delivery of those burnt cables on a holiday, which is contrary to the norms, my lords, which are prescribed there, they gave them two, my lords, undamaged and reusable cables, and which, my lords, there's an admission. Now, my lords, the learned single judge, I mean, because we then did the inquiry proceeding, there's no question of the competence, etc., is not challenged, my lord, of that. That's the finding in the learned single judge judgment. The learned single judge, my lords, held against me primarily on one count that the videography and the photographs were not in accordance with by not filing an affidavit on the section 65 capital B, has gone on a judgment of Roop Singh's, and then my lord says, and also my lords, the other judgments on 65 capital B. But my lords, in this case, my lord, there is an admission, there is not a confession.
The confession, the learned single judge disregards by saying it was retracted. This was not a confession. In a question and answer examination of the in a format of both the delinquents, the appellant Millards admitted to the fact that yes, they had given undamaged goods which were not part of the auction to the auction's purchaser, which were cables worth a book value of 16 lakhs. And Millards, they gave an explanation for it. The explanation was that because in some earlier auction, they had given some wrong information, that is the NRL, that is myself, and therefore the auction purchaser had earlier participated in the auction and he had suffered some loss. To compensate him for that, they had given it to him. And it's a long, detailed explanation. And if your lordship doesn't mind, your lordship may come to page 30. And then, my lords, the other part is that the learned single judge has mixed up two rules, because there is a procedure for premature retirement, which is not a penalty. The other one is compulsory retirement, which is a major penalty. He has said that the procedure for premature retirement has to be applied to compulsory retirement. Well, I'm reading these are two disparate separate rules. One is
Awarded the punishment of premature retirement.
No, he has said that we needed to follow the rule, the procedure for premature retirement for compulsory retirement. Compulsory retirement is a major penalty as far as I'm concerned, as far as my rules go. Premature retirement is not a major penalty.
What was the penalty inflicted?
Compulsory retirement.
Compulsory.
May I, take your lordship straight away to page 35, which is the statement, page 40, I'm sorry, Millards. Page 40. No. 40, Millards, is the, if your lordship sees at the top left.
40?
Oh, I'm sorry, page 35 at the top. The running pages of Millards. Because is the type. It is the statement of Sri Diganta Halavi. I also get there are two page numbers. Page 35, your lordship has Millards. It says the dated 3rd of April statements of Sri Diganta Halavi. Millards says Annex A.
Yes.
Yes, it's on the top right hand paging, actually running pages, which is the top right. Your lordship may just make a note of the date, 3rd of April 2014. Statement of Sri Diganta Halavi, Assistant Manager Commission under suspension given to Vigilance Officer on 2nd and 3rd April 2014 at Riverview Guest House. Your lordship may turn over the page and come to page 43 straight away. This is a question and answer, so this is an examination. Now there's the third truck was because there were 3 trucks which were loaded.
Please,
question number
2. Sir, be slow.
I'm sorry.
Please. Yes.
Page 38.
38, yeah.
I'm sorry, sir.
Yes.
Question number 10, if your lordship.
10.
Yes.
Yes.
The third truck was taken inside the lordship,
Yeah.
It was taken inside the warehouse to open yard 01, and 1 load of cables was loaded with the help of crane. Why was this cable loaded in the truck? The tender was for 2 parts. First lot CDU, VDU, fire damage ferrous and non-ferrous scrap materials. And the second lot CDU, VDU, burnt cables. The H1 bidder, Mrs. Telax, had quoted for both the lots. While the proposal for award was under process, the bidder came to know that they had wrongly considered certain items for the first lot, such as CDU, VDU, damaged air fin cooler 06 number, and other ferrous scrap lying inside scrapyard, which were actually part of another auction to be held on 24th of February 2014. They insisted that due to wrong information given by warehouse, they had considered these items and quoted a high price. Now they are unable to accept their H1 bid, and due to withdrawal of offer will forfeit their EMD amounting to rupees 1,75,000 for the first lot. The customer demanded warehouse to refund their EMD or compensate their loss of rupees 1,75,000. It was admitted by us that we had given incorrect information regarding the first lot, since the air fin cooler 06 numbers and other ferrous scrap was not marked as a separate auction. Due to the pressure of the customer, and myself jointly with senior manager materials, which was the appellant in the other petition respondent, decided to compensate the customer by handing over old crammed copper cable of around 1.5 ton lying in the 0Y01 for a long period of time. Approximately 1.5 ton of cable was given, because earlier cable was sold for around 85 per kg, and considering this rate, the value of the cable amounts to rupees 1.75 lakhs. Next question, ID 11. Who had given the incorrect information regarding to the bidder regarding the first lot to include air fin cooler and other ferrous scrap? I do not know who had given the incorrect information. Was there any material? You'll actually turn over the page. The other questions are also relevant. Page 44.
Yeah.
If I may read. I will read from the, because this shows the sequence. It's an explanation given, furnished by him. These cables were brought to the warehouse between 2007 to 2001. Mr. B.N. Das and Mr. Gautam Pal were posted in the warehouse. This is known to Mr. Gautam Pal, Mr. P. Boro, SM Materials Store Keepers, Dipen Chaudhary and supervisors, Mohan Gohai and Hamadhar Bora, and persons dealing with cable. Yes, there are other cables at present in the warehouse which were shifted from the cable yard to the warehouse at the same time. When were the earlier similar cables sold for around rupees 85 per kg, and where were these cables kept? Similar cables were sold by e-auction during September, December 2013 to Mr. Dilip Agarwala. These cables were from the instrumentation department and kept in the scrapyard. Regarding compensation to the customer, did you discuss the matter with anyone? Please give the names and designation. The matter was discussed between myself and Senior Manager Materials, who's the respondent in the other appeal. The approval note for accepting the H1 bid was cleared by finance on so and so date. However, on 3rd of March 2014, however, the next authority, DGMCL, had not approved the note. Please state the reason why DGMCL had not approved the proposal. I did not contact directly. However, it was learned from Senior Manager Material that DGM-CNL had reservation regarding the first lot CDU, fire damage, ferrous and non-ferrous scrap materials, and advised to segregate this lot into various categories such as MS, SS, etc., and go for re-auction. Since there were only cables in the second lot, you were asked to go ahead for the second lot seeking new approval as per you. Was any scrap disposal done during any holiday off day in the past? If yes, who were present during such dispatches? Yes, we had earlier disposed of on off day holiday to Mr. Sri. Now, and this is signed by the respondent at the bottom. Then your lordships may turn to page 40. That's the next page. At the bottom, this is a physical verification, if I may read at the top left, your lordship has. Physical verification of cables in open yard, 01. Verification done on 9th of April. That is 7 days after this examination. Verification done by Sri so-and-so, so-and-so. Your lordship may see page 24, item number 24. Item number 24, LT power cable so-and-so, about 635, I think it should be meters. It's in meters. So this is the cable which was given during the auction, which was not part of the auction. Part of
Given during
during the delivery of the auction goods, which was not part of the auction. This is the physical.
But verification done on 9/4/2000, verification done by so. These statements were recorded on 3/4/2000.
Then I'm coming to that. After that, next page. He reiterates it.
Just a minute. This examination of the witness was 3/4/2014.
Yes, madam.
And this verification of 9/4/2000.
9/4/2024. Because it was on the basis of his statement that this verification was undertaken. He then said that these were cables, or these were the cables, because this is the assistant materials manager and the senior materials manager who were in charge of the warehouse. The rest would not be aware of it. So they were asked, because may I just explain the genesis of the matter to your lordship? It so happened that when the delivery of the auction goods was happening, then there was a complaints filed by some journalists before the police. The police had arrived. When the trucks were taken out of my campus, because 3 trucks were loaded.
So first of all, you clarify what was the material put to auction?
It was burnt. There was a fire. It was burnt, scrap, and burnt cables.
Burnt scrap and burnt cables.
Please, madam.
And the cables which were delivered by these persons to the contractor were not part of the auction.
Were not part.
Around the cost of those cables were around 16 lakhs.
A book value, 16 lakhs book value. So that is the charge. Then, my lords, and it so happened that this incident came to my notice.
When the police arrived.
Yes.
What was the complaint by the journalist?
The journalist was that goods which are not part of the auction were being passed over auction goods and taken out. Good. So then the police arrived, and the police arrived, and the trucks were seized outside my campus, and then they were brought in. 2 trucks were unloaded. The 2 trucks were unloaded and they were burnt and scrapped. Now, in the third truck, when the third truck was in the process of being unloaded, at the bottom were these 2 cables, large copper cables of 635 meters. Then, when the complainants, who were the journalists, insisted that it should not be unloaded, because if you unloaded by crane, then they would said that it would be damaged and therefore it would be passed over as auction goods. So you inspected there. There was videography carried out by the CISF, etc. Now, the learned single judge has proceeded only on the ground that 65, because I did not file the 65 capital B affidavit before the inquiry officer, that this therefore has to be disregarded completely by discussing the law in this regard.
Whatever the video recording and all.
Yes. Now I say, let us accept that to be true. We go on his admission. And the learned single judge disregards the admission because he says the confession is retracted. Because this is of 3rd of April, when he makes the statement on examination and says that these were the goods and we took them from such warehouse. Subsequent to that examination, a physical verification was undertaken because these were two people in charge of the warehouse. Nobody else would have known. So then a physical verification was undertaken on 9th of April. And he reiterates again on the next day, at page 40.
Just a minute, Mr.
So this manager and that senior manager, both of them have filed this,
Yes, Manoj.
the same punishment was
Yes, Manoj.
both of them.
Yes, Manoj.
Will you leave this matter, what do you want to file any counter or what? No requirement of that.
Necessary will file, but the confession that he is referring to, that was under duress, and I have in my written statement, this statement that was taken was at the preliminary stage.
Those were the questions and you answered those questions.
That is what I have stated in my written statement. When they asked me to show cause, in the reply, I have specifically stated that this was under, they had already typed it out on a piece of paper, and I was just made to sign. And that is the stand I took in my written statement that I filed against the show cause. And that has been my consistent stand. And their own documents belies the fact that there was no material taken away at all besides the auction material.
Taken away at all, but since the police
Your Lordship,
police arrived there and then and there they seized that truck, then where is the question of taking away that material?
my lord, what had happened was, the facts are, let me place the basic facts. What had happened was, 3 truckloads were taken out of the NRL campus. Some local people agitated along with one journalist, they lodged an FIR, lodged a complaint saying that we suspect that there are some materials beyond the auction materials which are being taken away in the trucks. The police seized the truck and the trucks were brought back to NRL. They had independent experts, including officers from APDCL, to verify whether there were only scrap materials or reusable or unused materials also. They examined the trucks. First two trucks, there was no problem. In the bottom of the third truck, there were two bundles of cables that were found. The complainant said that we suspect that these are not within the auction material. And it was just a suspicion that was expressed. The APDCL people refused to comment, saying that we have not brought our equipment, give us some time. They subsequently submit a report saying that these are damaged material. That document was never even taken into account.
Whatever the cable was found, whether that was damaged or new or whatever it may be,
Scrap.
it was a part of auction or not.
Scrap. As long as they cannot, they have to, the first onus is on them to satisfy that there was actually some material beyond the auction material taken away, which was never established at any stage. And that is what.
There was a seizure memo by the police. Any seizure memo was prepared by the police?
No.
Apart from that videography and all.
No.
When the police case was there, certainly there must have been a seizure memo for that.
They were seized. There was a JIMA application, and accordingly, it was page 241. In fact, my lord, if you your lordships may just have a look at the inquiry report. That itself will. What had happened was.
Do you have that record of the inquiry?
Yes, well, it is there, page 142.
The inquiry report is at page.
I'm sorry, inquiry record is not been filed. Record. We can file it, no, because part of, before the learned single judge, because it was voluminous, we file it.
In the meantime, if you want to file any counter to it or otherwise. You are in requirement of filing any.
Everything is on record.
There's no need for that.
No, we'll have to.
Except the records maintained by them pertaining to the.
That is for the court, that is for the court, for issue notice. And the respondents are being represented through counsel. And it's no need to issue purple notice. Then it concept of the appellant is directed to produce and to keep ready the record of the inquiry by the next date of hearing. Is this matter for admission? Or
September.
25th of September 2024. In the meantime, the effect and operation of the impugned order passed by the learned single judge is stayed till next date of hearing.
We have been out of a job, my lord, after an extensive hearing.
It's not the same. Item 19 for the senior sales manager. Item 19.
Both the same inquiry.
I have something to say.
On the stay, my lord.
Yes, your lordship.
Your lordship will fix it for consideration of the interim order on 25th.
So we have simply a limited order on till next date. We have not passed any unlimited stay orders.
Actually, the problem is I was not even there at the time. I was not even there.
Just till next date of hearing, however, the prayer for interim relief during the pendency of this writ appeal will be heard on the next date of.
Correct.
Same order. Both.
Is it all right if your lordship can have it on 27th?
Prayer for,
Right, 27th.
prayer for extending this interim order will be.
30th. 30th.
On the next date of.
Can it be the 30th of September if it is not intermittent?
As 30th of September.
My mail is already out of work.
30th of.
I'm good.
Right.
Item 20.
I have been terminated from my service. I was a contractual employee for 19 years. And thereafter terminated. I think there is one judgment passed by your lordships. In a contractual, if even you are a contractual employee, even then an inquiry was conducted, then your lordship's view was that an opportunity has to be given. It violates that's I can just pass on the judgment. I think bang on this point. But the learned single judge, my lord, distinguished because of that Purushottam Dingra's case, my lord.
Was present to service.
Kindly first see my lord.
Lordship.
Because your
In
lordship
this case,
judgment.
Lordship, the age control society is the main party, Lordship, and they have a separate council. And their name is not reflected in the Causley's Lordship.
Who is who is appearing on behalf of that? Society?
On behalf of the P Nayak is appearing, Lordship. P Nayak.
Okay, fine, my lord. We'll.
Pick up the matter tomorrow, Lordship.
It's no problem, my lord. We'll give a copy. I think he should be, if he's there, then we should serve a copy to him.
We should know this.
Because there is, on this point, my lordship has decided.
That's it.
I got the judgment. Page 9, kindly see for a moment. Your lordship will issue, just for a moment, see page 9.
Yeah.
Exact similar point. See page 9. It is no doubt correct that in a case of contractual engagement, terms and conditions of contract were governed by service condition of the employee. In the present contract agreement signed upon it does not have a clause permitting termination of contract at any point of time the service rendered by contractual staff was not found to be satisfactory. However, what is to be noted here in the bare perusal of the impugn order of termination demonstrate on the face of record that same was issued on the basis of finding of the inquiry proceeding conducted behind the back of the petitioner, wherein it is projected that the petitioner is guilty of misconduct. Here also same matter. Therefore, order of termination of service of petitioner dated is not based on allegation of misconduct, but the same is also stigmatic on the face of record. In other words, the impugn or termination was founded on allegation of misconduct. However, the petitioner was not given opportunity of being heard in this matter. Therefore, it is a clear case where respondent acted in violation of principle of natural justice. I think,
Notice.
yes.
So and so. Is appearing on behalf of respondent.
I am appearing for 1 and 3, Lordship.
1 and 3.
Yes.
Mr. P Nayak is appearing on behalf of the respondent number 2. Service is therefore complete. List this matter for admission. And for consideration, list this matter for admission at for final disposal at admission stage. On when
Any.
30th of September.
September.
30th of September 2024. While reflecting the name of the respective councils for the respondents.
There is one judgment of the Supreme Court also found. The lordship has passed this order. 2022, there is a judgment of the Supreme Court. You cannot. There has to be a notice. I'm deeply obliged.
Item 21.
Excise.
One of my pawn shop license was cancelled on the ground that I shifted the shop.
Not shifted. You have placed some wrong facts before the.
No,
according
that
to
is
the
what they
application.
say, my admission
You
is
don't have
there.
Don't have any restaurant or something else and you put a flex on a other restaurant and shown the premises of yours.
My lord,
This was
the
the allegation again.
my lord, the inquiry report, my lord, which was prepared by them after the appeal I had filed before the Board of Revenue, my lord. That copy was not given to me. My lord, my admission is there, my lord, my own in writing, my lord, that I'll place before your lordship, my lord. But only issue here, it seems, my lord, there are two provisions, my lord, two penalties given, my lord, under the law. One is, my lord, for infraction of, my lord, conditions of license, my lord. One is straight, my lord, cancellation of the license, and the other is, which I am relying on, is on, my lord, Rule 58B, my lord. That, my lord, that is also quoted in the impugned judgment, my lord, page 112, my lord. It starts at 111, page 111 of the writ appeal paper book. Your lordship will kindly see.
Yeah.
58, my lord. As a waiver being the holder of a license, permit or pass granted under this act, or being in the employ of such holder and acting on his behalf, A, fails to produce such license, permit or pass on the demand of any excise officer or of any other officer duly empowered to make such demand. Or B, my lord, B is not relevant to us. Your lordship will kindly come to the, it is wrongly printed as B, my lord, but the last one, C, it should be C. With fine which shall not be less than 50,000 rupees, but which may extend to 5 lakh rupees, and the convicting magistrate shall direct the offender to be imprisoned in default of payment of fine for a term. So, my lord, even if they, my lord, they can, my lord, give me a second chance, my lord. That is what I want to say. My admission, your lordship will kindly appreciate. My lord, I'll place that, my lord. Page 61, man. This is addressed to the Deputy Commissioner Lakhimpur, my lord. May I read this, my lord? Humble submission that I, Sri Deepak Borwa, son of Sri Bubul Borwa, Dulhat, is an unemployed person. I had applied for opening an Indian made foreign liquor shop at Dulhat, Tinali, Naboisa for my settlement before the Department of Excise. In this behalf, inquiry report was submitted by the Excise Department. Based on the said inquiry report, the government has approved the license to me. Accordingly, the Deputy Commissioner has granted license to me. Due to ignorance of Excise Act, I started a new house for my shop in the same dark near my restaurant. I also admit that I have not informed the department about the new shop, my lord. Basically, for this, my lord, infraction of this section, my lord, anything so far as shifting is concerned, my lord, that I have to take prior approval from the district commissioner, man. There's a condition of the license, man, which I violated. After this, my shop was suspended by the excise
No
department.
question of condition of license is violated. In fact, you have given wrong information.
No, my lord, the
along
dogs,
with your application,
my lord, my dogs are adjacent.
whatever it may be adjacent, then you should have indicated your space. Why you have indicated that restaurant? By putting a flex on that
My lord, at
building
the-
of that restaurant, and you shown that this is my restaurant.
My lord, at the
There was
relevant,
some Ma hotel. and
yes, my lord.
DGB, the DG
Belonging to
restaurant,
one Ananda Mandal, my lord.
that was not in existence at that time. Your, whatever the restaurant was not in existence.
My lord, this was
Later on, you shifted to the nearby plot,
no, my land is there, my lord. The adjacent plot, my lord.
but there was no construction, sir.
My lord,
On that
no,
land, that was a vacant land.
and I informed the superintendent, my lord, Dharveli, that is my stand, my lord. I didn't, my lord, and he was not in
Your
the inquiry.
admission is there that yes, you have wrongly mentioned this place. You don't have any such place. What remains then?
But my lord, in view of this provision, my lord, may I just pray, my lord, that, and my lord, I have also looked up, my lord, I didn't find, my lord, regarding, my lord, re-inspection, my lord, inspection and, my lord, grant of fresh license, my lord, that I have not found in the statute, my
Such
lord.
persons are not, we can't grant indulgence to such persons, and particularly for the purpose of this liquor sale. Again, apply for it. You are having that place, again apply for it.
My lord, for that, my lord, they have to, I think, advertise and all that, my lord.
So then advertise, what's the problem?
In fact, I made this submission before the a single judge also, my lord, that, my lord, in view of the 58C, my lord, by imposing some cost, my lord.
It is not.
It is not that I didn't have land, my lord. My land was in the adjacent plot. My
This license was valid up to for what time?
My lord, that is it. It is the next, my lord. Validity to citation.
This license is for 2 years or 1 year?
Hmm?
Yes, Mr. Consul.
Yes, my lord.
The license is for how, what period?
1 year.
1 year only.
It is not mentioned in license.
Subsequently renewed lordship.
Huh?
Subsequently it is renewed lordship.
The renewal provision is there, but the license is initially for 1 year. Where is that mentioned in this license? Page 57. Yes, be it known as concern so and so in a restaurant, where it is mentioned that it is valid
till,
for
my
1
lord.
year.
1 year to go to sleep.
Where is that?
It is not there.
It is in the 26/4/22 to 31st March 2023. And the currency, the period is already over.
But
1 year period is already over.
no, my lord, it happened, my lord, this litigation, my lord, started, my lord. But initially the appeal, my lord, and then the,
At two.
my lord. Okay.
May I take the liberty of mentioning a matter, Lordships? This matter was mentioned in the morning, item 32, due to some miscommunication, we were not there. There is some urgency in this matter, would Lordship, if so convenient to your Lordship, fix the matter on 16th of September. There was a
For the request made by them.
Yeah, no. I'm not objecting to the adjournment today. I'm just saying, since there's some urgency, would Lordship be kind enough, if it's convenient for your Lordship, to fix it on 16th? 32.
And they have fixed it on?
Yeah, they are all here.
Only adjourn. So if the order sheet is not signed, then we'll change it. Otherwise, if it is signed, and you please get this date from the registry, because we have simply adjourned it.
Lordship, that's,
We have not given any date.
that's Lordship. So that is therefore, can it be 16, Lordship?
Sir, since if the order sheet is already signed, then we can't change it.
Very good.
Otherwise, we'll get it changed. The
Grateful.
court master will inform you.
Grateful, Lordships.
Your lordship wanted to know the length of the tenure of the license, my lord. It is given for a period of 1 year, my lord. In this case, my lord, it was granted in the month of April 22, 23. And the cancellation of the license happened about 2 months after the grant of the license. And then we filed that statutory appeal, my lord, before the Board of Revenue, and thereafter we came.
That 1 year has already expired. Otherwise, also we can't direct you to run the shop.
No, my lord, this license is renewable license.
Renewal license.
That is provided, my lord, in Rule 128, man.
First of all, for that, we have to revive that license.
My lord.
For the purpose of renewal, at least license must be there, so we have to revive that license.
Now, the initial order passed by the Board of Revenue also directed in the interim to keep in hold on that license, man. So that direction was there, man. Your lords will kindly look up my lord page. Even as the Board of Revenue, page 65, man.
Yes.
The last para.
Yes.
Para 6, in view of the aforesaid, this court without commenting on the merit of the appeal or of the impugned order deems it fit to remand the case back to the Deputy Commissioner Lakhimpur for fresh disposal of the case after disclosing to the appellant the conditions of license which have been violated and giving the appellant an opportunity of being heard. The impugned order shall be kept, next page, man, on hold till disposal of the matter afresh by the Deputy Commissioner Lakhimpur. And thereafter the order was passed, my lord, and which was challenged before the learned single judge. And hence this appeal.
Yes, moving on.
We have received complaints against this petitioner lordship, IMFL shop lordship. Subsequently, inquiry was conducted.
You are for
I'm for department lordship.
Excise Department. Excise Department, all the
Deputy Commissioner.
Yes. Yes, yes.
Can you see the inquiry report lordship, page 84.
Page
84.
82.
Start from 83 lordship and relevant is lordship 85 lordship. Page 85 lordship.
Yes.
Down below observation lordship.
Yeah, read.
Based on the field visit, documents verified and statement recorded, the following observations can be drawn. Sri Deepak Borua, this is the petitioner lordship, has acquired the IMFL on license in the name of DB Restaurant at Dolohat, Tingali by providing false land documents and open the shop at a totally different location than the one mentioned in his application. Sri Deepak Borua submitted land details bearing DAG number 771 and Patta number 125 new of Dolhat Revenue Village, lot number 2 of Naoboisha Revenue Circle, which does not belong to his father, Google Borua. The restaurant premises shown by Deepak Borua as DB Restaurant during site verifications belongs to Mr. Ananda Mandal, covering DAG number 789 of periodic Patta number 244 of Dolhat Revenue Village, lot number 2 of Naoboisha Revenue Village. The restaurant located at the land covered by 789 of periodic Patta number 244 of Dolhat Revenue Village is named Ma Hotel and his owner is Ananda Mandal. So it is very much clear that lordship. He is running the shop in the place some other person's lordship. And land documents was also not belongs to him lordship. And something like this, the complete violations of the license conditions law.
No, my lord, one thing, my lord. First of all, the complaint itself was directed, if your lordship will kindly permit me to show, my lord, page 81. This complaint was, page 81 may kindly be seen once. How casually they have carried out this inquiry. The complaint was against one Sri Joyanto Borua Bulahati Tiniali of Lakhimpur Hodor. Your lordship will clarify. Page 81. And the appellant, our petitioner before your lordship is Deepak Borua, my lord, son of Bubul Borua.
Lordship, there is some error in the name, but in the inquiry officer, in the inquiry report,
Then
reference of this letter is there.
my lord, at page 85.
This letter, lordship.
My lord, at page 85, my lord, the observations.
Yes.
The second observation. In particular, Deepak Borua submitted land details bearing DAG number 771 and Pata number 125 new of Dulahat Revenue so-and-so of Naboisar, which doesn't belong to his father, Sri Bubul Borua. My lord, these land documents we have annexed here at page 95.
Where is your reply to the chokehold notice?
My reply, my lord. What is it? Reply. My reply is there.
61 page.
Page 61. No. After Show cause notice is page 67 and my reply is at page 68. The appealance land is DAG 771 and Pata 125.
Yes.
Here they have in the observation, my lord, they have stated, my lord, the Deepak Borua submitted land details bearing DAG number 771 and Pata number 125 Dulahat Revenue Village of Naota, which does not belong to his father Bubul Borua, my lord. The documents are otherwise.
But this the inquiry report is not under challenge now.
This is taking things too far, my lord. If their own documents, my land documents, my lord, the government documents, my lord. And this inquiry report was also not furnished to us, my lord, with the show cause notice, my lord. Your lordship may notice at page 67, my lord. This was given only in the affidavit that they filed before this court, my lord. That's all. My lord. So, my lord, I would just like to, my lord, resubmit, my lord, that in view of this existence of section 58B, if it's possible, even if by imposing the cost, we can, I may be. I'm grateful.
The learned single judge wide order dated 7/6/2024 passed in writ petition numbers 1745/2023 has refused to interfere the action of the respondents of cancellation of the license for selling IMFL, Indian made foreign liquor, in favor of the appellant on the ground that the appellant has obtained the license by furnishing false document. Full stop. The department, the excise department has cancelled the IMFL license issued in favor of the appellant on which the issuance of date of license.
24/4/2022. 24/4/2022.
On 24th of April 2022. On receiving a complaint to the effect that the appellant has provided false document regarding the place for which the IMF license has been on.
IMFL on license.
IMF
On license.
on license was obtained. And later on, the appellant has also illegally shifted shifted the place to a totally new location. Stop. On receiving the said complaint, inquiry was conducted in which a show cause during the course of inquiry, a show cause notice was issued to the appellant. And in reply to the said show cause notice, the appellant has admitted his mistake, but has submitted that due to ignorance, he has committed the said mistake. Full stop. The inquiry officer in the inquiry has concluded that the appellant did acquire the IMFL on license in the name of DB Restaurant at Dula Hat Tinali by providing false document and also shifted the restaurant to a totally new locations in breach of rule or condition of license under section 58, subsection B of the Assam Excise Act 2000. Full stop. Having heard the learned counsel for the petitioner and after going through the material available on record, particularly taking into consideration the fact that the appellant did acquire the license by furnishing false information, we are not inclined to interfere in the impugned order passed by the learned single judge, hence writ appeal is dismissed.
My lord, I just, my lord, may I be given liberty to challenge the inquiry report, man, which was not challenged, man, that's a fact.
Question of inquiry report now.
Much obliged, my lord.
Item 22.
My lord, in pursuant to the last order, my lord, some missing autonomous.
The Autonomous Council of Assam, my lord, 3 councils are there. They were implemented as a party, my lord.
Yes.
Perhaps.
I'm for Dimahasa, Lord. This is our instance.
You are for?
Dimahasa Autonomous Council.
What
Not
about
Kasai,
other-
sir.
This Bodoland and Karbi along? Who are those councils? Their names are reflected in the.
3
Yes,
months,
Lord.
my lord, they were there. Now, my lord.
So, the 2 last instruction here.
Karbi Anglong is not shown.
GC and DHS.
This is.
So delay in working plan, my lord, preparing working plan in the different district.
Preliminary work to-
Yes, sir.
On behalf of the teacher, here to receive instruction.
From whom?
PT. Bodoland Telecom. Here to
You are for the Bodoland Territorial Council and this madam is also.
Not
Dima
Kasai.
Sao.
Yes, Lord.
Who is for Karbi along?
Also the nominee.
Joint to suggest. Yes, okay.
Lord Karbi Anglong, Jayanto Chutia, Lord, he is the council is there. I will inform, my lord. I will inform him.
Did you file any response to this query?
Here to receive instruction. That one still awaited.
Madam, you file an affidavit of this.
Okay.
Okay. Ms. Swanto is appearing on behalf of the Dima Autonomous Council. And Ms. Bora is appearing on behalf of the Bodoland Territorial Council. They place some time to file respective affidavits in response to the query of this court raised wide order dated 25/7/2024. It is informed that Mr. Jayan
Jayan Chutia.
Jayan Chutia is appearing or is the counsel for the Karbi Alliance Autonomous Council. Stop this writ petition after 4 weeks. In the meantime, the 4 weeks after showing name of Mr. Jayan Chutia for Karbi Alliance Autonomous Council and the other respective councils appearing for the different respondents. By the next date of hearing, the response on behalf of all the 3, on behalf of all the 3 councils be filed.
Item 23.
May I please, my lordship, may I plan adjourn, short adjournment for the time being.
No, I'm for the respondent 1, my lord.
Who is appearing for the 2, 4 and 5?
I appear for respondent number 3, Department Council of Litigation.
3. Who is appearing for the respondent? You are appearing for Mr.
One, my lord.
One.
Yeah.
What about 3, 4 and 5? 2, 4 and 5.
4 and 5.
Notices have not been served till date.
That was deleted in Lordship. IO was filed
In fact, the appeal has been preferred by the Guwahati University. The respondent number 2 is the principal of the University Law College.
When it was removed from the array of the respondents. No such order is there.
And interlocutory application was filed, and at that time, the respondent number 2, 4 and 5 was deleted.
Have you filed amended cost title?
Yes,
Have you filed amended cost title?
yes, Lordship.
You have already filed. Okay. The IA preferred on behalf of the appellants. IA number 2318 oblique 2024. Preferred on behalf of the appellants in this writ appeal. With a prayer to delete the names of the respondent number 2 and 4, 2, 4 and 5 from the array of the respondents has already been allowed on 7/8/2024. Hence, there is no requirement of issuing notices to the respondent number 2, 4 and 5. At the request of the learned counsel for the appellant, list this matter after 6 weeks.
Lordship, can this matter be fixed on Friday, Lordship?
6 weeks.
Lordship,
You are not ready to argue.
Lordship, my senior counsel is on legs.
Ask your senior counsel to appear after 6 weeks. Yes, next.
Item 24. May I please, your Lordship? Yes, this case is relating to Lordship selection of president and vice president of the schools, Lordship. There is a notification dated 27/6/2016, that is page 58, regarding selection of president, vice president of the assembly, page 61, page 58, Lordship. This notification is dated 27th of June 2016. And relevant portion, Lordship, will find page 61. Bottom, Lordship, selection process of president and vice president of SMDC. The inspector of schools, after consultation with the principal, headmaster, and the local people, will forward 2 names to the director, secondary education Assam, for each president and vice president, with the recommendation of the deputy commissioner within a period of 30 days. After considering the names, Director Secondary Education Assam will provide the list to the government with his comment for selecting single name. After comparing date of both the candidates, and then government will approve the committee. Then thereafter, another notification is issued, partially modified that notification, Lordship. Power is vested with the deputy commissioner, that is page 65.
What about the writ?
Lordship,
Writ is pending.
it is pending, Lordship.
Get the writ petition decided itself. Why you want
Lordship,
to
my,
get it decided?
here is the case, interim is discontinued, Lordship.
Interim is
Inclined
discontinued way back on, in the November 2023.
23, Lordship.
Then in October 2023, almost 10 months have passed.
Lordship, in the middle, this
Then,
may be
how
disposed
can
of,
we
Lordship.
revise that interim order?
The interim, Lordship, there are the interim order of this code, Lordship, that is page 18, because of violation of the notification.
We understand, sir, but kindly, this interim order was vacated on 9/10/2023, and after 10 months, how can we revise that interim order? Get the writ petition itself decided at the early date.
Here is the case, while issuing this notice in the state writ petition, Lordships stated that the returnable date interim prayer will be considered.
Having heard the learned concept of the parties and after going through the material available on record, we are of the view that the controversy raised in writ petition number 5239/2022 is required to be decided finally by the learned single judge and no learned single judge. It is learned single judge and in such circumstances, it is not appropriate to consider. It is not appropriate to adjudicate the order impugned dated 9/10/2023 passed by the learned single judge, whereby the interim order passed in writ petition number 5239/2022 is vacated by a detailed order. Stop. Hence, the writ appeal is disposed of. The writ petition, the registry is directed to list the writ petition number 5239/2022 before the appropriate bench after 2 weeks. With these observations, the special appeal is disposed of.
Item 25.
Yes.
My lord, in this case, my lord, the petitioner arranged chief secretary only the party respondent. I have communicated to the office of the secretary regarding instruction, my lord. My lord, the office of the secretary informed me that, my lord, Director of Social Justice and Empowerment is the necessary party and they have separate standing council. A letter has been written by the
Chief Secretary is the party only.
Yes, my lord. Chief Secretary written to the Directorate of, my lord, Social Justice and Empowerment to give instruction, and Directorate on Social Justice has their separate standing council, my lord.
We are not concerned with that, sir.
My lord, that is why, my lord.
The state is the party here.
That's true, my lord.
This department is the party, the department is
My lord,
separate from the state government.
no, my lord. My lord, the Chief Secretary.
We don't want this. You file reply to this.
My lord.
Whoever the authority may be. File reply. By what time you will file the reply to this?
My lord, I have communicated.
There's a separate council and separate department and nothing else. We are not concerned with that.
My lord.
File affidavit on behalf of the state.
Fixed time you can be in that time.
We have already earlier granted you the time on 24/7/2024.
My lord.
More than a month.
My lord, I have communicated to that, my lord.
But that is not our headache. You have communicated and
I
they
have not received that
communication and they
instruction
are not
only because, my
responding.
lord,
That is your
that
headache.
the Chief Secretary has, my lord, instructed that.
Whatever it may be, Chief Secretary has instructed to whom, we are not concerned with that. We want reply to the writ petition.
Right.
If you want, then.
Well, if 3 weeks time may kindly be granted, I will.
Last opportunity is granted to the state government. Last opportunity of 4 weeks' time is granted to the state government to file counter to the writ petition, failing which appropriate cost would be imposed. Just after 4 weeks.
Obliged.
Item 28.
That department and that secretary has informed Banana, and that secretary is going to ask this and that, and what is this? State ka response, file the response.
Every initiative has been from the Directorate of, my lord, Social Justice and Empowerment. That is why, my lord.
Whatever it may be, ultimately is the state of, the department of the state government.
Department of State Government.
Then.
Since, my lord, they have.
Don't make these excuses here in the future, okay?
My lord.
That they have a separate council and they'll come and then they will respond and be.
My lord, my lord, humble submission before your lordship, my lord. If, my lord, they implemented, my lord.
Where is the need of that when the state of Assam is the party, the law is of the state of Assam, which department it is, we are not concerned with that. File your reply.
My lord.
Please practice.
Item 28.
Yeah, please open. Lordship, on last order, Lordship, a reply has to be filed, Lordship, that reply. And we have,
Yes, Mr. Majumdar, you got time last time. Is there any requirement of writing any reply?
My lord, the reply would not be necessary. In fact, by complying with the orders of the single judge.
You have
with
complied
respect- my lord, we have sent the nominations to the concerned minister. On his approval, my lord, the new committee will be, the new president and vice president will be appointed. The procedure requires that the nomination has to go through the deputy commissioner to the concerned guardian minister, as you call it. Once the approval comes, we make the appointment.
Yes, what remains?
yes, Lordship.
What do you want to say?
Lordship, you do note, Lordship, that is page number 16, Lordship. The, in here, Lordship, Deputy Commissioner, Lordship already gave the name, Lordship. Page number,
Para 14 of the judgment. Last three line. Learned counsel appearing for the parties have fairly submitted that the nomination of the respondent number 5 and 6 was not so made after their names were empaneled by the school authorities in the manner as contemplated under the guideline as notified by notification dated 27/6/2016.
yes,
The guidelines for the purpose of this nominating president and vice president are laid down under this notification dated 27/6/2016. And you are admitting that your recommendation or this appointment nomination was not in accordance with that guidelines, then certainly what's wrong? Leonard Single has rightly said so. Have admitted that these guidelines have not been followed. That's all.
that is true.
That is true. Then what remains in that?
Kindly fix for the next date, Lord.
What next date? We are going to stop now.
No, Lordship, kindly. Lordship, the next date will be granted, Lord.
Next date, so the next date, this your concession would rebut or what? क्या हो जाएगा? What would happen to that? You have consented before the fairly submitted. In fact, you were fair before the Leonard Single. This is unfair here in division bench.
Lordship, Lordship, I have to instruct
The
senior, Lord.
nomination of the appellant, your president or what?
Lordship, at least two of them, president and vice president.
Who suffer both this vice president and president? The nomination of the respondent of the appellants as president and vice president of the School Management and Development Committee of Rampur, Chalapar Sahid Ali High School was interfered by the learned single judge, taking into consideration the admission on the part of the counsel for the parties that their nominations as president and vice presidents of SMDC was not in accordance with the guidelines issued notified by notification dated 27/6/2016. The learned single judge has remanded the matter to the concerned authorities to initiate fresh selection process for the post of president and vice president of the SMDC of the school in question within stipulated time. Stop. Taking into consideration the fact that it was the case of the it was fairly admitted on behalf of the appellants before the learned single judge that their nomination on the post of president and vice president of the SMDC of school in question was not in accordance with the guidelines issued by notification dated 27/6/2016. We don't find any illegality in the impugned order passed by the learned single judge, hence this writ appeal is.
Item 29.
Lordship, may kindly pass over the matter for some time, Lordship.
What?
The senior counsel I Chaudhary will be arguing the matter on behalf of the respondents, just for some time, Lordship.
Sometime when?
Today,
Today itself.
today itself, Lordship.
Pass over for the time.
Lordship.
Item 30.
May please, your lordship. My lord, if the made appeal, my lord, the response has not been filed by in the IA, my lord. For stay, the response has been filed. In the meantime, my lord, I have also filed another IA. Because what happened, my lord, although your lordship issued notice, no stay was granted. In the meantime, they have started computing the, my lord, the salary. Your lordship knows, and because of that, I have not been paid my salary. Bishop to higher copy ponable. Bishop I to copy ponable high court. High court, high court.
Now, what do you want?
Now, my lord, I am without salary, but for July, my lord, I have not been paid salary. Because of the, my lord, they have started
Salary, now
computation.
they'll pay you the salary of the peon.
My lord, that is the issue your lordship will
That
decide,
is the
my
issue
lord.
that has rightly been decided by the learned single judge because you were promoted temporarily in place of a person whose services were terminated.
My lord.
Ultimately, that person was reinstated by a court order.
Yes, my lord.
Then you were reverted back to the post of peon.
Yes, my lord. My submission
So,
before lordship is
you
that,
are
my lord.
entitled only for that salary. Now, how can you claim salary of a driver?
My lord, the till my lord 2006, 14, my lord, I was rendering the service of a driver.
That was on account of a vacancy due to the termination of one person.
True,
Ultimately, he was reinstated on that vacancy, then you have to revert it back to that.
My lord, that person has been given the, my lord, pay protection, but there is another aspect. But the fact remains, my lord, I have rendered my service as a driver. It fault is the of the
For
authority.
For that, the learned single judge has already ordered that no recovery for that purpose.
Yes, my lord.
And whatever the benefits you got it, they'll remain with you. But since the day when you were reverted to the post of peon, you are entitled for salary of peon. That's all.
My lord, from the date, my lord, when I was reverted in 2014, my lord.
Certainly, on that day, you will get the.
No, my lord, the honorable single judge says from 2006.
No. It is clarified that the refixation of pay scale, that is from the pay and allowances resulting from such refixation will have the prospective effect and date of this order. There shall be no, there shall not be any recovery. That's all.
No, my lord, if your lordship goes further, the direction that calculation has to be, my lord, pay to be refixed from 30/10/2006. From 2006, my lord, but I was, my lord,
But that person was reinstated from that date.
my lord,
That
I
person was
have,
reinstated from that
yes,
date.
my lord, but then, my lord, I have received my salary for this period. And my lord,
Received your salary, therefore no recovery.
my lord, the recovery, my lord, they, from that, or that day, my lord, when I was reverted back. I was reverted in 2014, my lord. If it goes to 2006,
Who is appearing for the state? Paying the salary of the post of peon, why you are without that salary?
My lord, due to my lord refixation, my lord salary has been stopped, my lord.
Now pay him,
My lord,
now pay him. Paying that salary, you should pay him.
salary for the post of peon, my lord. That can be done.
Likhe, Mr. D.K. Sharma, learned, additional senior advocate, government of Assam, has submitted that after refixation of the pay grade of the petitioner, of the pay scale of the appellant, the salary would be paid to him within a period of,
My lord,
the due salary would be paid to the, shall be paid to the appellant within a period of
3 weeks, my lord.
3 weeks from today. Just after 3 weeks, we'll see to it.
Right. Oh, my lord.
we do don't, not even.
Item 31.
My lord, that,
Coordinate
interim,
bench
my
of
lord,
this
on the
honorable
first
court
day.
has already dismissed similar petition.
Yeah.
Coordinate bench of this honorable court has dismissed similar petition.
My lord, when the interim order was initially granted, my lord has, my lord will see the first order pass.
Similar, same judgment, my lord, in two cases. But they did not bring it to the notice of the.
No, my lord, that was
Division bench
subsequently
regarding-
listed, my lord, after my lord has
Just a
granted the stay.
If he is made a sufficient, bill, we have to consider it. And if the impugned same judgment has already been set, not interfered by the division bench, do you expect that will interfere in that?
No, there were issue in both this, my lord. Legal issue was same, my lord, but there were two different writ petitions. No,
Only way out is.
no, that order we are already contemplating to challenge. But my lord, my humble submission, my lord.
Then do one thing.
when my,
to make things easy for you, we'll pass the separate order, you file the two appeals. That would be better.
what my humble submission, what when the matter was, this writ appeal was taken at the first instance, my lord, lordship has, my lord, the interim order, which was passed, my lord, has prima facie expressed an
But now
opinion.
that prima facie opinion,
And my lord, that was placed before the another coordinate bench, my lord, but, my lord.
that is the, that
No.
was the prima facie opinion. Now this final opinion is here. They are bound by it.
What is
Mr.
it?
Gupta, don't talk like your client. You're a lawyer.
No.
You know what is the issue.
That was a separate petition, the same point was same, na?
She was same, my lord.
Legal and counsel for the appellant. Learning counsel for the respondent has submitted that the division bench of this court in writ appeal number 261/2024 decided on 9/8/2024 has endorsed the view taken by the learned single judge in the impugned judgment. Full stop. It is submitted that the learned single judge in the impugned judgment has opined that when a constituent member of the joint venture submits a tender on behalf of the joint venture, a power of attorney is not required to be submitted along with the tender. It is submitted that in view of the fact that the view expressed by the learned single judge in the impugned judgment has been affirmed by the division bench of this court. This writ appeal preferred on behalf of the impugned, preferred on behalf of the appellants against the impugned judgment is liable to be dismissed. Full stop. Learned counsel for the appellant though not in position to dispute the fact that a similar view expressed by the learned single judge in another writ petition has already been affirmed by the division bench of this court. Wide order dated 9/8/2024 passed in writ appeal number 261/2024 has attempted to argue that this court, while issuing notices to the respondents on 5/8/2024 has prima facie opined that the view taken by the learned single judge may not be may not be correct. Therefore, the matter may be heard on merits. Full stop. Having gone through the judgment dated 9/8/2024 passed by a coordinate bench in writ appeal number 261/2024. We don't find any case for interference, hence this writ appeal is dismissed.
Not that initially, my lord, it was the submission of the respondent, my lord.
Respondent tell me.
No.
Item 33.
This is that disability reservation matter. They have filed an additional affidavit, the private respondent repetition. Almost changing the dimension of the case. We'd like a little bit of time to respond to it. Now they are trying to, the expert, your lordships had referred the matter to the authority. And they have said that it is
permanent disability.
and it with surgery it can be cured. Now they have brought in some materials to show that they have visited some other doctors and their opinion is different, therefore.
No, yes, my lord, that's correct. Here,
Let them file their response.
We are asking for just a week or 10 days time.
And it concept for the appellants, place for granted time to file counter to the additional affidavit filed on behalf of the. No, you have filed this.
I filed the affidavit and reply to the affidavit opposition filed by medical authorities.
And the concept of the appellant place for and granted time to file counter to the affidavit reply filed on behalf of the appellant.
Not the appellant.
On behalf of the respondent, in response to the affidavit reply filed on behalf of the respondent number one. List after 10 days. Interim order if any to continue till next.
And may I note a date.
Date doesn't matter.
Can it be on 11th?
Okay.
Obliged. Obliged.
Supplementary list, item 39.
May it please your lordship. Lord, a contract for supply of liquid medical oxygen was awarded to the appellate by the authority, my lord. Now, the learned single judge has interfered with that order. Now, my lord, the case is otherwise on a very narrow compass. If your lordship would kindly come to the bid document, my lord, at page 89. It starts at page 89. Prior to this, there were 2-3 tenders, my lord. That is, those are not under challenge or anything. Your lordship would kindly come to page 91. This is the part of GEM tender, my lord, issued by the authority. It was issued by the Director of Medical Education. Please come to clause number 4 at page 91.
Yes.
Past experience of similar service. The bidder must have successfully completed similar services over the last 3 years. That is current financial year and the last 3 financial year, ending month of March prior to the bid opening. The 3 similar completed services costing not less than an amount equal to 40% of the estimated cost. Two similar completed services costing not less than amount equal to 50% of the estimated cost, or 1 similar completed service costing not less than amount equal to 80%. So as far as my lord past experience is concerned, if it is one work, it has to be of the 80%. If it is 2, 50%. And if it is 3, then it has to be 40%. Now, my lord, this is a general clause, my lord. This is a default clause. Now, if your lordship would kindly come little below the scope of the work, has your lordship got it, my lord? Now, let us see the stand of the government. Government has awarded us the contract, my lord. Now, government has explained the position in their affidavit. If your lordship would kindly come to page number 212. page 212. This was the employer, governments or the purchaser's understanding that the bid document section on past experience of similar service referred to in page 3 of the bid document under clause 5, past experience of similar service is a default GM generated template for past experience of similar service in the service category bid, whereas on the bid document, scope of the work referred to in page number 3 of the bid document under the scope so and so, the past experience criteria outlined in point number 3 of the terms and conditions under technical specification for a supply of liquid medical oxygen, which states that bidder must have experience of supplying to minimum one government private hospital of minimum 300 or more bed. They should have experience in supply of LMO, supporting copies of supply or order, contract, approved price list with satisfactory completion certificate. Any other document in support of this must be provided. And the aforesaid clause 3 supersedes the above mentioned clause 4 as per the disclaimer at page 8 of the bid document, which states that this bid is governed by general terms and conditions stipulated in the bid and service level agreement specific to this service as provided in the marketplace. However, in case if any condition specified in general terms and condition is contradicted by conditions stipulated in the service level agreement, then it will override the conditions in the general terms and conditions. Now, my lord, this was the specific stand of the government. Now, my lord will kindly come to page number 91 again, my lord. Sorry. Yes, sorry. My lord will kindly come to page 96. Now, on top heading is disclaimer. Then lordships will come towards the bottom. This bid is governed by general terms and conditions. Conditions stipulated in the bid and service level agreement specific to this service as provided in the marketplace. However, in case if any condition specific in general terms and condition is contradicted by the conditions stipulated in the service level agreement, then it will override the conditions in the general terms and conditions. So, my lord, the petitioner's case is clause 4 of the GEM contract, that is the eligibility criteria. That is how the eligibility criteria is to be assessed. The government, as in my lord, employer, they have clarified their position. This is our understanding of the meaning of the contract. Now they say, when you click that, then what appears is, my lord, the condition number 3, which is at page number 98. And kindly at page 97, my lord, kindly see the heading. Technical specification for supply of liquid medical oxygen. At page 98, serial number 3. The bidder must have experience of supplying to minimum one government private hospital of minimum 300 or more bedded. They should have experience in supply of LMO, supporting copies of supply order, contract, approved price list with satisfactory completion performance certificate. Any other document in support of this must be provided. So in our humble submission, my lord, this is clause number 3, which will determine the eligibility criteria, not clause number 4 in the GM contract, which is, my lord, in every contract it is there. Whenever there is any special terms and conditions specified in terms of the disclaimer, it is the general terms and it is the special terms and conditions which will prevail. Now, in support of this, we have given, there is no dispute. Now, the work was awarded to us. The matter pertains to supply of oxygen to the hospital, my lord. Now, the learned single judge's understanding, lordships will get at page number 344, para 37. Now, at page 30, 5, my lord. At page 343, state as well as our stand was recorded. Then para 37 is the finding of the unlearned single judge. Para 35 at is page 343. The case of the state respondent is that clause 4 of NIT is a standard terms and condition, which is always there in a tender issued under GEM portal. And same is in conflict with the additional terms and conditions, that is ATC. ATC would prevail over GTC. Thus, only clause 3 of the terms and condition is to be considered by the state respondents for considering whether a bidder has past experience for supply of LMO earlier. On the other hand, the stand of the private, that is appellant, is that clause 4 of the NIT was a general terms and condition, and clause 3 of the terms and condition was STC, and STC would prevail over GTC in terms of the special service level agreement. The submission of the respondents' counsel do not appear to be correct. In view of the fact that preamble at clause 1A2 speaks of service-specific terms and condition contained in this document, if the above was to be read into the clause past experience, then clause 4 of the NIT would have to be an STC, as clause 3 of the terms and condition is a general terms and condition. Further, this court failed to see the conflict between clause 4 of the NIT and clause 3 of the terms and condition, though it is quite apparent that quantification or qualification with regard to what constitutes past experience of a bidder regarding similar past experience for supply of LMO has not been spelled out in terms of.
Mr. Chaudhary, see, whatever be the facts, it appears that the learned single judge has virtually awarded the contract to one of the parties, open the financial bid and award. That certainly is not permissible. If the single judge finds that there is a flaw in the process, in the evaluation process. All that was permissible is declare that the process is illegal and ask the authorities to carry it out afresh. But here the single judge has evaluated the tender and come to a conclusion that subject to opening of financial bid, the writ petitioner should get the contract. So prima facie, this order does not appear to be sustainable. Now, how do we can't do the final hearing today? Both of you
I will
please
hardly
suggest.
take 10 minutes to address both on merits as well as the reason why, what has.
Whatever be the reason.
No.
That's beyond the scope of writ court. Writ court cannot award a contract.
If your lordship comes to the direction, what is the direction issue?
My lord, if my bid goes, then no, I'm just pointing out, my lord. Okay.
I will, firstly, my lord,
You come, this quote is the view technical bid last para.
Yes.
51. Respondent could not have been declared to be responsive in the absence of any material to show that he has the capacity and financial ability to perform the contract work that he has been produced any of the documents in terms of clause 4 of so and so. Consequently, the finding of the respondent bid as responsive is hereby set aside. Further, as all other subsequent consequent action thereto, the price evaluation uploaded on so and so, there also here. The matter is remanded back to the state respondent to consider the case of the petitioner for award of contract regard being head to his financial bid amount.
two reasons, ma'am.
Such direction.
As has rightly fallen from your lordships, normally this kind of a direction is not.
Normally, it is not at all permissible. The court can remand the matter or relegate the matter for fresh consideration of all the respondents while declaring it that his bid is not responsive.
The reasons are twofold, madam. In this particular case, number one, it pertains to supply of liquid medical oxygen. Number two, in any case, if his technical bid goes, I'm the only one who remains in the fray.
So it is open for them to go for retender.
Yes.
But the learned single judge is
That
not-
also has a reason. That is why this is a case. Just a little bit of background facts are necessary. I will quickly, without troubling your lordships with any of the documents, I'll quickly give the background facts. There are three. There have been, before this, there have been 2 rounds of tenders. First round, there was a NIT issued. There were clauses for determining the eligibility. The appellant participates. His technical bid gets rejected. He files a writ petition. That writ petition is still pending. There's no interim order. I was awarded the contract. There was no other party who had participated. Now that period gets over. A fresh NIT gets floated. Terms and conditions are there for determining the eligibility. Now he submits, this time, he submits an application saying that you relax all these conditions. The authorities say, all right, we are relaxing ABC conditions, but rest of the conditions that you are asking for cannot be relaxed for certain reasons. Reasons are given. He does not even have a manufacturing unit at all. They relax all that. He goes to a party from Bhutan in violation of the Make in India policy of the government of India. That is also relaxed. We do not object. Now, after all these relaxations, he submits a tender. This time we point out that in spite of all the relaxations, he still cannot fulfill. Instead of proceeding ahead with the tender process is cancelled.
Earlier round, in this matter, earlier round of litigation.
That my lord had the occasion to deal with.
The same case?
No, that pertains to liquid oxygen, but it pertains to, that was liquid nitrogen, but it pertains to a different tender. This is by the government of Assam Health Department for all the medical colleges and hospitals of Assam. Now, what had happened, after we pointed out that in spite of all the relaxations, he is not able to fulfill the criteria, they find that they cannot come out of the records. Instead of proceeding, they cancel the whole tender process. This time they come up with a tender where virtually everything is relaxed. The only clause that remains to determine the experience is clause 4 that has been there, which was pointed out. Now, they ignore clause 4 entirely and award the contract to the appellant. Then we file the writ petition saying that how that is the only criteria that has remained. How could you have ignored it? Now, what has happened is, he was awarded the contract on 11th of July. And this is, your lordship will kindly make a note, take note of this one.
Which contract? This contract?
This contract on
Financial bid has not been opened.
no, financial bid was open. He has quoted a much lower bid because in Bhutan, the electricity prices are much lower. I cannot match his prices. The work was awarded to him. Your lordship will kindly see within 15 days. Your lordship will just have a look at those pages, man. 11th of July, it was, work order was issued on him. A show cause notice had to be issued on 26th of July. And your lordship will kindly have a look at the first page, man. The language employed by them, the authorities. That is why we were saying that he does not have any experience, any eligibility. Your lordship will kindly have a look at the language. And now ultimately he has surrendered and he goes to the chief minister, writes a letter saying that I should be compelled to make the supplies to him so that he can in turn make the supplies to the government. That also we have, and all these documents have been suppressed.
No, what is this show cause notice?
Your lordship will kindly see, on 11th of July, work order was issued to him. On 26th of July, a show cause notice is issued. Your lordship will kindly have a look at the language. Whereas it has come to the notice of the undersigned that Meghalaya Oxygen, that is the appellant, has repeatedly failed to fulfill its contractual obligation. This is medical oxygen to the hospitals. And your lordship will kindly have a look at the next page. How he responds. He says that I am unable to, and he is trying to put the blame on me. Your lordship will kindly have a look at page number 4, the language used.
Yes.
Sir, I would give my submission that on 26 July 2024, the tanker had little engine problem. And there was huge traffic jam from Khanapara to GMCH after doing the weighman. And still we managed to supply LMO by 1 p.m.
10/8/2024.
No, my lord. The page prior to that. He is responding to the show cause notice.
This 11th day of August 2024. Urgent need of liquid medical Assam under DMA. Where is that?
First page is the show cause notice.
Yeah.
2 pages after that is his reply to the show cause notice. And the second page of his reply, your lordship will kindly see the first paragraph. And your lordship will, in the next page, your lordship will find the letter addressed to the chief minister, where he is saying that
There is something missing.
Something is not right.
there is 11th of, there is a letter dated.
So where is your reply to the show cause notice? It is not here in this. The show cause notice 26 July 2024. The respondent number 3 is this appellant has replied to that notice. Where is that?
That is in the, should be in the 3rd page. There's
The 3rd page.
There is a letter dated, subject itself says show cause notice for inadequate.
That is number 5. Get the pagination corrected here. Number
May I have
5.
the other copies that I have just provided?
Other copy, what to do with the other copies? Yes.
2nd day of August. Your lordship may skip the first portion. Your lordship may skip over to the next page. He is himself admitting that on that particular day, sir, I would give my submission that on 26 July 2024, the tanker had little engine problem, etc., and there was huge traffic jam from Khanapara to so-and-so, and still we managed to supply LMO by 1 p.m. We have received order on previous day so-and-so. Therefore, the statement multiple instances is baseless. Secondly, sir, so and so, which belongs to GMCH, were due for hydraulic testing, and when we receive those cylinders, we need to do complete inspection, etc., etc. But now, if your lordship kindly turns to the next page, he has written another letter to the director. This time he says,
Yeah.
in the second paragraph, sir, due to some technical problems in the manufacturing plant of our supplier, SD Cryogenics, from whom we have been supplying the liquid medical oxygen, there will be interruption in production and supply of liquid medical oxygen for 3 days. Your lordship will imagine a hospital going without oxygen for 3 days. And then next paragraph, your lordship will see, sir, kindly note that our second source, Inox Air Products, is also unable to provide us liquid med. So their second source has also failed. And next page, your lordship will find a letter to the Honorable Chief Minister of Assam, and your lordship will kindly see the contents. They are saying that the writ petitioner should be directed to supply to them so that they can supply to the government. Absolutely unheard of. And these documents are suppressed. Your lordship will kindly peruse the second paragraph of the letter to the Chief Minister. Sir, due to technical issue in the plant, our plant has shut down. And the spare parts which was supposed to reach few days earlier from China is reaching on Tuesday. So we are unable. And from 11th of July, we have reached 11th of August. Sir, in the meantime, we have requested L2, Premier Cryogenics, to supply LMO to us. This is exactly what we had contended before the learned single judge, that this party does not have any eligibility whatsoever. And that is why they are saying that you ignore clause 4 so that they can become eligible. And presently, because they have failed to supply, the government has requested us, and on humanitarian considerations, we are supplying at his rates. And this has been going on since 11th of July. Today, we are on 28th of August. Your lordship may pose a query that is he in a position to supply tomorrow? I am not saying for today. This requires supplies every day. 24/7 supplies are required. And that is why the learned single judge noticed that it was done in such a hurry. Within 2 days, technical bids were opened, financial bids were opened, and he was sought to be awarded the contract. That is why the writ petition itself was taken up for disposal at the motion stage itself, considering the fact that it is medical oxygen. And your lordship will just have a look, the extent to which the mischief has been done. Yes. So what they have done is, there is a clause, if your lordship will kindly come to page, page 98 for a moment. Your lordship will kindly come to page 98 for a moment. There is a condition in the NIP, clause 10, towards the bottom, your lordship will find. During emergencies such as pandemics, it is mandatory for participating bidders to promptly supply liquid medical oxygen to any of the medical colleges in Assam. This must be done at the approved L1 rates. Failure to comply with this requirement will result in the bidder being blacklisted and barred from taking part in future bids. This clause has been applied because he is not being able to supply. This clause has been applied to compel us to make the supplies, to fill up the gap. This is the extent of his incompetence.
Written order? Is there a written order or request or what?
But we have annexed some of the supply orders. We have given in the compilation.
So, Mr. Gogoi, you see, uh, our objection is on a very, very technical legal principle. Because after the judgment of SB Vora 2006, 4 SSC and all, this law is well settled. When a mandamus can be given. Mandamus is to be given to compel the authorities to pursue or to compel them to perform a statutory duty or a legal duty. Now, in a tender matter, even after opening the contract, it is open for the authorities to not to award it to either party and go for a retender. So the direction of the learned single just cuts across that legal principle. Therefore, in the present form, it will not be maintained. That you can take it for. But at the same time, the facts are glaring. This man, appellant, appears to be totally clueless and is totally incompetent, and you are still supporting him. He is unable to supply even a single cylinder.
All the orders have been issued when he failed to supply during the pendency of the dispute, not the trial.
No, then why? What is your stand? Are you supporting him?
These documents are provided fairly, I can
Yeah, these are your documents, you have written to them, you issue show cause notice, and still you are asking.
Come in, my lord. This show cause notice was placed before the learned single judge also.
We placed
But of course you placed. And my lord, this was considered by the learned single judge.
Not in the judgment.
No, but it was very much before the learned single. This show cause notice was produced by them. My lord, if there is a technical flaw, if the machineries are something is wrong with the machinery, what's wrong in saying that I will take till Tuesday, I will rectify the defects and resume supply?
Till Tuesday, it's okay, sir, 1 or 2 days.
No, my lord, today I don't take.
They are supplying the oxygen at the.
No, that's not correct. No.
He has placed on record.
After the judgment, my lord, because the judgment has interfered with the order of the authority. That's why. Now the question is, my lord, my humble submission is very simple. Under the CBC guideline also, as well as in terms of the Honorable Supreme Court, my lord, if there is a single technically qualified bidder, then it's a case for retender. Now, the learned single judge did not accept that. But that is one of my ground in appeal.
That has been amended.
That one of the, my lord, CBC guideline says if they are left with only one technically responsive bidder, in such a situation, invariably, it has to go for retender. The reason is very simple, my lord, there is no competition. Now, secondly, here is a case, my lord, they are relying upon certain documents which were very much before the learned single judge when the matter was adjudicated.
No mention about the.
Yes, this is notice on place condition.
All notice
Categorically, the open court says that since the issue is regarding the selection of the private respondent.
No, my lord, my case is very simple. Para 37 of the impugn judgment, whether it can be sustained. Read with para 51. My lord, the learned single judge has not only evaluated the tender, learned single judge has also tried to give any meaning to the clauses over and over what was understood by the employer. Is it permissible, my lord? And in fact, I placed a judgment which learned single judge referred also.
That we'll consider.
Yes.
We'll consider that is the,
Yes.
whether this clause 4.
Yes.
The terms and conditions.
Whether-
Required to be taken into consideration.
Yes.
Or together, clause 4 and 3 are to be taken into consideration.
And my lord,
Is to be seen.
yes,
Whether
and
it
my
is
lord, one more
mandatory,
aspect.
directory, these are things we'll have to.
No, my lord, since it's a question of supplying of oxygen.
uh,
No, my lord, there is a
Just-
clause.
just-
I'm very sorry to take 1 minute time, my lord. In the order, final work order, which has been given to us, it has been given to him also as a L2 bidder in case of emergency is required to supply. There is a provision in the clause.
That is there.
Yes.
Emergency is created by him. The lack
No,
of,
whether-
lack of his competence.
No, we'll file an affidavit to what
We
you have
also
said.
file.
These are the documents which he has supplied. Take the copies of these documents and what is your response? Let us know by tomorrow.
Yes.
Mr. Gogoi, this is a serious matter. It's not only about a tender.
Tender.
If we don't find convincing answers, we'll summon the director day after tomorrow personally. In fact, you can ask him if he can come, it'll be good.
And in the meantime,
What really is being sought to be done, we want to know.
They were issued during the pendency of the litigation. We had no occasion to go ahead with the blacklisting and all, if any penalty.
Whatever, you give us.
That is altogether different thing.
Indefinitely.
It is not,
We don't know, as Mr. Chaudhary has argued, that earlier tender was issued, the conditions were relaxed, so and so, and coupled with the fact that you have not been able to supply this, then it's a serious matter. It's a matter of.
Consider this part, the so-called was issued, not that it has not been issued, immediately it was issued. But during that time, the petition was pending, and within a week or two, it has been hard, and order was passed, considering the urgency of the matter.
You respond to this by tomorrow. We are keeping this one with us
I will give a copy. We'll give a.
tomorrow.
Yes.
Tomorrow.
Passover meter 29.
We have learned our lesson from the pandemic. Whatever the court, who gets the conflict with parliament? We are not least implementing the parliament. Because, right? On the processing of
May I please do? Yes. Nothing here, your lordship, facts in after learning this, your lordship.
29.
29. Now, your lordship, the ONGCL, your lordship, respondent authority, your lordship, quoted a tender, your lordship.
Yeah.
Floated a tender for your lordship, hiring of 372 numbers of your lordship, light motor vehicle, your lordship.
And your lordship, accordingly, we submitted our tender, your lordship. Thereafter, your lordship, they issued corrigendum and extended the time of last date of filing of tender. In the meanwhile, what had happened here, your lordship, certain organizations from the local area, your lordship, started demanding that this system they have been following, your lordship, that should be disbanded, your lordship. A lottery system should be followed, your lordship. And ultimately, capitulating to that demand, your lordship, they cancelled the tender, your lordship, and there is a demand.
If they have to run their corporation
Lordship.
in that area, they have to go by the demands of the local
Lordship,
people. Otherwise, every day they'll face some.
Lordship,
Problems or
that's my
challenges.
case. Otherwise, your lordship, that they are well within their power to, your lordship, cancel a tender, your lordship, go for fresh, your lordship. No doubt about that, your lordship. Only thing, your lordship, when demand is like this, so we declare bond, there will be a strike in the entire ONGCL area, and in view of that, your lordship, by yielding to those demands, your lordship, whether the authority can cancel a tender
whether
process. Now, your lordship.
Looking to their opposition, whether you will be able to execute the contract.
No, we have been all along, we are executing the contract, your lordship.
Now, if there is a.
But your
demand,
lordship will kindly see
many
what will,
things which-
ultimately what will happen, your lordship. Today, there are some organizations are coming and demanding that.
Initially registered.
Today, your lordship, some organizations are coming and demanding that this is the.
These are the matters which are really we know that should not happen, but these are the things which are the realities. And day in and day out,
Lordship.
we are seeing this everywhere. Initially the government resisted, and then they relented to the pressure of the local people, rightly, wrongly, whatever it may be. These are the things in which if the courts come into that, that's better.
Lordship, that's your lordship, what has found from your lordship. But ultimately, your lordship, these are the consideration for cancelling a tender, whether it will be an arbitrary decision or not, your lordship.
We admit, yes, this should not be, but there are many things where this has to be. Karna pade. What else? They
Lordship,
don't have any other thing.
if your lordship takes that view, your lordship, but otherwise, your lordship, my case is this, your lordship. Tomorrow, some more organizations will come and say that yes, this is not the procedure to be followed by the ONGCL. They will have to follow the procedure we are asking you to follow. Now, ultimately, had it been a case,
We'll decide it, whether such, this pressure tactic should be allowed or not, we'll decide. We'll decide this.
your lordship, the problem is this, your lordship,
Yes, we'll consider
they have
and decide it.
consequence.
Pass a judgment on this.
Pursuant to there has been a change in the policy of ONGC. Based on that policy, we have floated a tender.
They don't have any objection to that. You are
No,
well within your rights to change the policy, but the way in which you have changed it, they are objecting to it.
That also is not factually correct. But in any case, my lord, had all consequences of bans and strikes been bad, Indian independence would have been struck down by the British courts long back.
Your lordship, Supreme Court, this honorable court has declared ban to be an unconstitutional, your lordship. In spite of that, your lordship,
there is
and tender committee.
Actually, it is not correct.
The Supreme Court has also declared that the strikes by the lawyers are always illegal.
Lord,
Despite
that's-
that, you
that's-
people are having the strikes and we can't do that anything. That is there.
Oh, your lordships are taking action against that, your lordship. Yes, that has been.
Having heard the learned counsel for the parties, we are of the view that matter requires consideration, hence admit. No need to issue notice. The parties are already represented. Parties are represented.
Yes.
Parties are already represented. However, in the facts and circumstances of the case, no case for grant of interim stay is made out. Interim there is rejected. We'll consider this is an important point you have raised. We'll consider it and decide.
Right.
Obliged. Item 34.
Lordship, in this case, I am appealing on behalf of case owner counsel for UGC. Lordship, due to arising some personal problem, Lordship, he is out of station. Can it be taken?
Inform the other side.
Lordship,
Mr. Chaudhary is here.
Lordship.
Yes, my lord, they informed me yesterday.
As per Lordship's direction, as per Lordship's direction, I have prepared.
What is this?
Your lordship, my lord, directed
Lordship
that
has
we should
directed
give
last
a
occasion to Lordship.
compilation.
Lordship regarding the judgment which was also referred by the Lordship as per the matter of this case. As per Lordship's
You
direction,
have heard this matter?
Lordship,
Yes.
Lordship has heard this matter is a part of matter, Lordship.
UGC criteria.
Like to have a my lord, copy of their compilation, my lord.
Already I have given the citation.
All the citations he has given.
Give a copy of the compilation, you are a mighty state.
Take mine if you don't have.
No, Lordship.
You are a mighty state, why you are so miserly?
One thing, Lordship, just by Lordship with apology, I am saying, Lordship, Lordship has already parted the matter, Lordship. Yesterday, they have filed another affidavit, Lordship.
No,
They have filed a Lordship additional affidavit, Lordship, bring some reports, Lordship.
my lord,
Yesterday, they have filed, Lordship.
that affidavit-
Without the leave of the court, Lordship, they have filed a Lordship.
My lord, the
Otherwise,
additional
I have nothing to say, Lordship. Just I point out, Lordship.
Okay, then ठीक है. You, if you want to file any response.
Lordship, we will not file response, Lordship. Just I point out, without the leave of the honorable court, the parted matter in the midway, Lordship, they have filed.
Am I appealing for?
Lordship,
Case of law.
UGC. At the request of the learned counsel for the UGC, the matter is adjourned for a next date. However, it is made clear that the matter may not be treated as part of this bench. We'll release it from part. We'll hear on the any other day.
Lovely.
Lordship, compilation will be taken as a part of the record, Lordship.
Which one?
Compilation take as a part of the record, Lordship.
Will be there in the compilation. Yes.
Lordship.
Item 36.
Please, your Lordship. The matter may be adjourned today, your Lordship, and fix another date.
Any other day,
My lord.
but the request of the learned counsel for the appellant, let this matter after 6 weeks.
No, sir.